Good morning, everyone. Thank you for joining us for the Medical Board of California's quarterly board meeting day 2. While this meeting is being conducted with participating board members and staff at the Los Angeles meeting location, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments from those who wish to speak will be heard for each agenda item, from individuals attending in person and remotely. To be ready for remote public comment, we ask you please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see View Additional Meeting Information link on the first page of the meeting agenda item for the information on connecting to the meeting and accessing meeting materials. Thank you, President Lawson. I'll start the meeting.
Thank you, Sean. Good morning, board members, staff, and members of the public, and welcome to day 2 of our November quarterly board meeting of the Medical Board of California. I'd like to first ask all the board members to please turn your devices to silent. So please check your computers, your watches, your cell phones, so that there aren't any disruptions during the meeting. For members of the public, you may notice board members accessing laptops, phones, or other devices during the meeting. They are using these devices to access board meeting materials that appear in electronic format. If you are a member of the media and require assistance or information, please see Aaron Bone, and Aaron has identified himself. This is an official board meeting of the Medical Board of California, and disruptions of the board's business will not be tolerated. Government Code Section 11126.5 does allow a board to remove people who willfully interrupt a meeting and to clear a room if order cannot be restored by removing or muting the disruptive people. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak, please raise your hand or come forward and you will be recognized. As Sean mentioned, this meeting is being streamed via WebEx. Individuals attending the meeting remotely via WebEx will have an opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating this WebEx event will activate the hand raising and Q&A features of WebEx and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment, but this time period may be reduced depending on the number of people who wish to speak so that more people may be heard. The host will audibly announce when 30 seconds remain to conclude the public comment, and after the individual's time for public comment has lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. I do want to remind the speakers to please stay on topic and keep your comments to 3 minutes or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we do plan to end today by 3 p.m. So with that, I'd like to call the meeting to order at 9:08 a.m. And Ms. Struther, please call the roll.
Dr. Ayala Rodriguez.
Here.
Dr. Bolat.
Here.
Ms. Chung.
Yes, here.
Dr. Helzer.
Here.
Ms. Mitchell. Dr. Mahmood.
Yes.
Ms. Rimke.
Here.
Dr. Thorpe.
Here.
Ms. Torres.
Here.
Dr. Sai.
Here.
Mr. Watkins.
Here.
Dr. Yip.
Here.
Ms. Lawson.
Here. Thank you. A quorum is present. And just a reminder again, all action items will require a roll call vote. We'll move on to agenda item 11, which is discussion and possible action related to the Midwifery Advisory Council. I think we have Madeline Weisner with us.
Good morning, everyone. Can you hear me okay?
Yes.
All right. Good morning, board members, staff, and members of the public. My name is Madeline Weisner, and I'm the chair of the Midwifery Advisory Council. I'm pleased to provide you with an update on the MAC, and I will be requesting a motion to approve agenda items for the next MAC meeting. The last MAC meeting was held on September 12th of this year. At this meeting, the following actions were taken and the MAC was provided with the following information. We approved meeting minutes from the May 30th MAC meeting, received an update from the MAC chair, received an update on midwifery legislation, received an update from the task force on Medi-Cal related issues, received an update on the midwifery program and the LMAR, voted on the 2025 MAC meeting dates, and no applications were received for the vacant public member position on the Midwifery Advisory Council. So the vacancy notice was reposted. The next MAC meeting will be held on January 23rd, 2025, and I'd like to ask for you to approve the following agenda items for that meeting. These items are approval of the minutes from the September 12th meeting, report from the MAC chair, report from the task force on Medi-Cal related issues, an update on midwifery related legislation, an update on the midwifery program, selection of one new MAC member to fill this public member vacancy, presentation on midwife access to audiology equipment for newborns, accessibility and sustainability of California midwives, a discussion on presentation to the medical board, and finally a presentation on the licensed midwife annual report and opportunities for better data collection. May I have a motion to approve the requested agenda items for the next MAC meeting?
So moved.
Second.
Thank you, Dr. Helzer and Dr. Balat. And thank you, Ms. Weisner.
Yeah,
Are
thank
there
you.
any questions or comments from the board members? Are there any comments from the public present in the hearing room? Any public comments on WebEx, John?
If you wish to make a public comment, you can use the hand raising feature, type anything in the Q&A window, or if you're on a call only line, you can press *3. Give you a few seconds to queue up here. First up here, we have Black Patients Matter. Line is open.
Yes, thank you. So Black Patients Matter here. Agenda items in the future with the midwifery section, it would be a benefit to update us on the morbidity and mortality rate of African American patients and how that is being addressed, corrected, assisted, because that is an ongoing issue that we would like to continue advocating for in the future. Thank you.
Thank you for your public comment. This time there are no additional requests in queue.
Thanks, Sean. We'll bring it back to the board. And Ms. Struther, if you could please perform the roll call vote.
Dr. Ayala Rodriguez,
Yes.
Dr. Bolat,
Yes.
Ms. Chung,
Yes.
Dr. Helzer,
Yes.
Dr. Mahmood,
Yes.
Ms. Remke,
Yes.
Dr. Thorpe,
Yes.
Ms. Torres,
Yes.
Dr. Sy,
Yes.
Mr. Watkins,
Yes.
Dr. Yip, Ms.
Yes.
Ms. Lawson.
Yes. Thank you. That motion passes.
Thank you. This concludes my MAC update.
Thank you, Ms. Weisner. We are going to now move on to agenda item 12, which is discussion and possible action on a new legislative proposal to establish a physician health and wellness program. And before we dive in, I just wanted to offer some framing comments, maybe my own point of view with respect to the context, because we're here today to discuss a very important legislative proposal. It's the potential establishment of a physician health and wellness program in California. Again, this initiative reflects our shared commitment to protecting patients while also addressing the complex challenges faced by those who provide care. And I think we should begin by candidly acknowledging our past. California's previous diversion program failed to meet the standards of accountability and effectiveness that patients and the public deserve. Multiple audits highlighted systemic shortcomings, including inadequate monitoring, poor safeguards, a lack of consistent enforcement, and that ultimately led to the program's termination. These failures caused real harm, and we must honor those lessons by ensuring any future program is built on a foundation of rigorous accountability and public trust. However, the absence of such a program here in California has created a very real void. California is now one of only a few states in the country that do not have a physician health program, placing us behind nearly every other state in addressing physician impairment. Across the country, well-designed programs grounded in best practices offer a dual benefit. They protect the public while supporting physicians in need. And these programs demonstrate that early intervention paired with robust monitoring actually reduces risks and enables physicians to recover and safely return to practice. I also want to point out that our societal understanding of substance abuse and mental health has evolved significantly over the last 15 years since the diversion program was terminated. We now recognize these as medical conditions that require compassion and treatment rather than stigma and punishment. A modern physician health and wellness program must reflect this shift, creating pathways for physicians to seek help confidentially while maintaining strong accountability measures that prioritize patient safety. I want to take a moment before we begin to thank our board staff and the task force for their dedicated work in developing the draft proposal before us today. Their efforts provide a very strong starting point for our discussion. And as we deliberate, I encourage us to focus on listening to the public, to stakeholders, and to each other so that we can identify opportunities to refine and build on this proposal in ways that best serve the people of California. The stakes in this discussion are high. Every opportunity to identify and rehabilitate potentially impaired physicians before harm occurs is a step toward safer healthcare for all. By building a program that is informed by past failures, that's supported by best practices, and that is reflective of modern attitudes, we can both protect patients and provide physicians with the help they need to recover and thrive. I look forward to today's thoughtful and constructive discussion. And Ms. Torres and Dr. Yip, I will turn it over to you.
Thank you, Ms. Lawson. I encourage the members to turn to Agenda 12, Item 12 in the materials. Dr. Yip and I are on the Physician Health and Wellness Program Task Force, and we participated in an interested parties meeting on October 24th, 2024, to hear from the public on the draft legislation for the Physician Health and Wellness Program, also known as a PHWP. The draft legislation is included as Attachment 1. 64 individuals attended the interested parties meeting, including some board members and staff, and 11 people provided public comments, with most providing support that the proposed legislation is on the right track. Additionally, the board received 5 written comments from the public, which are included in the meeting materials for this agenda item as Attachment 12.
Good morning. As documented in staff memo for this agenda item, the board had a diversion program that ended in 2008 following reports by the enforcement monitor and the state auditor revealing multiple serious program failures that put the public at risk. The failure of the board's diversion program was cited by legislature as one of the reasons for passing SB 1441 in 2008, which required the development of the uniform standards regarding substance abusing healing arts licensees. In 2017, the board became authorized to establish the Physician Health and Wellness Program, but the program would be required to follow the uniform standards, including for volunteer participants. The board developed proposed regulations to establish the PHWP and published them in the September 2023 for public comment. But after receiving overwhelming negative comments from numerous stakeholders, the board decided to re-examine the legislation establishing framework for the program. At the May 2024 board meeting, we heard from subject matter expert Dr. Christopher Bundy and Dr. Paul Early on the best practice for future health programs. Following the board's discussion and consideration of public comments, the board made the determination that the existing statutes authorizing the PHWP would not allow us to create a program that would meet the best practice for future health programs. Consequently, the board voted unanimously to not proceed with the regulation on the PHWP and instead asked staff to draft a legislative proposal for a PHWP that would meet the best practice. Ms. Torres.
The board's primary mission is consumer protection. A well-functioning physician health program will play an important role in protecting consumers by providing early intervention, treatment, and monitoring to physicians and other healthcare providers who may have a physical or mental health condition that could impair their ability to practice in a safe, competent, and professional manner. We are sensitive to the negative history of the prior diversion program, and we are aware that a successful physician health and wellness program will have to be appropriately funded, staffed, and accountable to ensure that it is treating and monitoring participants appropriately and communicating with the board when required so that the public is protected. We also want to create a program that the healthcare community will actually use. And the proposed legislation is a foundation for building a PHWP that meets nationally recognized best practices.
I want to thank Ms. Lawson for putting on this task force. After working with Ms. Torres, our public member, and our staff, I strongly believe our common goal is public protection. And as Ms. Lawson said, we're one of 3 out of 50 states that do not have such a program. So I think I encourage all of them to be open-minded and let's work together and make it happen. Thank you.
Mr. Bone, over to you.
Thank you and good morning, members. Nice to be with you all. Sean will be bringing up a PowerPoint presentation that we put together. We thought that might help to aid the discussion. It's a lot of detail to go through, and hopefully this helps to provide added clarity as we discuss this. First, I'll start with some high-level comments that just touch on the key features of the proposal, and then after that, go into more detail on each section of the proposal. We felt that the cleanest approach was to repeal the existing statute that authorizes the regulations that the board decided to stop pursuing in its May 2024 board meeting. The direction at the time, as you've heard from our task force members, was to develop a proposal that meets national best practices, which we believe is what's before you. Requiring the program to be administered by a 501c3 nonprofit helps to ensure that the mission of the program remains paramount. Using a 501c3 could help facilitate the acceptance of donations. This proposal is exclusive to the future and current licensees and registrants of the program, of the board, and is intended to help address any impairing condition, not only those related to substance use. A key feature of the proposal is that the board would not be required to impose the uniform standards on a voluntary participant. The proposal explicitly states that the board may refer someone to the PHWP instead of disciplining them. But very importantly, this would not be allowed for licensees who are alleged to have committed sexual misconduct or have allegations involving harm to a patient or client. Confidentiality is a core component of the proposal, but there are also clear limitations and exceptions which will be discussed later in the presentation. It's not working. Next slide. Thank you. The proposal includes language providing civil liability immunity for those who work in and around the PHWP and a reporting requirement for licensees to inform the board or the PHWP of a possibly impaired colleague. The proposal allows the board to appoint an advisory committee, one or more advisory committees, to assist the board's work related to the program. Beyond passing the type of legislation that's before you today, there's much additional work to do before a PHWP is up and running. Perhaps most significantly is that the funding for the program is currently undetermined. Also, the board will need to write and execute a contract and may need to complete regulations. Next slide. Now we'll move to a section-by-section description of the proposal. This first section, 2340, see the header up at the top, lays out the vision, which is to protect consumers through early identification, support, treatment, monitoring, and rehabilitation of current and future healthcare professionals regulated by the board for any condition that may impair their ability to practice in a reasonably safe, professional, and competent manner. Next slide. The rest of this section defines a number of very important terms that are used throughout this proposal. This slide includes some of the examples. Moving on to the next section, 2340.2. Thank you. To establish the PHWP, subdivision A of this section requires the board to contract with an administering entity. Paragraphs 1 through 9 of the subdivision outline the scope of work for the contract. In addition to those specifically stated items in this subdivision, the board may add other items to the scope of work in a contract. Subdivision B states that the board and PHWP are not required to impose or follow the uniform standards for those who are voluntary participants. However, it also states that the board and PHWP may choose to impose some or all of the uniform standards on that voluntary participant, which is someone who chooses to enter the program of their own accord, including someone who agrees to do so in lieu of discipline. Subdivision C makes it clear that a participant who is on probation must comply with all the terms of their probation and states that the PHWP will provide the required evaluations, treatment, monitoring, and reports pursuant to that probationary order. Participants would still be bound by the terms of their probation if they are on it, including the consequences for violating that order. Next slide. This section also, now we're on to 2340.4. This section requires the board to contract with a 501c3 to administer the program. We've included language that is intended to provide additional flexibility to the board to enter into a contract that exceeds 3 years. This is with the goal of fostering trust between the PHWP and the board and other stakeholders and avoid unnecessary disruptions in care, which is one of the elements that was emphasized by our experts in May. This code section also details out the key qualifications of the administering entity, including their experience with rehabilitating impaired healthcare providers and the treatment network that they would be required to use. These subdivisions in this section also describe who shall be eligible for services, essentially current and future licensees or registrants of the board. The terms for these groups are defined in section 2340. Next slide, please. The same section also requires the PHWP to make prompt and diligent efforts to conduct appropriate assessments, make referral for independent evaluations when appropriate, and attempt to enroll those with a condition that impairs or may impair their ability to practice in a reasonably safe, competent, and professional manner. The PHWP shall also have a board-approved system for immediately and confidentially reporting participants to the board. This includes reports of participants who withdraw or are terminated from the program. Finally, the section requires regular communications to the board and periodic evaluations of the program's operations, funds, records, and management to ensure compliance with the law and the board's contract. Next slide, please. 2340.6 lays out various procedures that the board must include in such a contract. I will not read these slides, but these next slide, please, Sean. These are just the outlines. There's 17 procedures in total. Next slide, please, Sean. We hope that this is a sufficiently comprehensive list. However, the board can also add any other additional procedures in the contract. Next slide, please. 2340.8 discusses a really key authority that would be granted to the board. That is to refer licensees to the PHWP instead of taking disciplinary action due to their unprofessional conduct. There is a very important limitation to this authority, which is that any licensee alleged to have harmed a patient or client or engaged in sexual misconduct is not eligible to be diverted into treatment. The licensee must agree to this diversion and agree to be responsible for the related costs, although other sources may be used to pay these expenses. If the licensee does not agree to enter the PHWP or fails to successfully complete the program, then discipline will continue to be an option for the board. Subdivision D of this section states that evaluation, treatment, and monitoring shall be performed by those with expertise working with impaired or potentially impaired healthcare providers. In subdivision E, we see the options available to the board to handle situations when it becomes aware that an unidentified voluntary participant committed a program violation. The board would become aware of this through its regular interactions with the PHWP and possibly in conjunction with an advisory committee, which I'll discuss in a moment. Upon such notification, the board has three main options. First, to encourage the continued involvement in the PHWP with additional conditions in lieu of discipline, if it is determined that the licensee can practice in a reasonably safe, competent, and professional manner. Second, request from the program the licensee's identity, contact information, and a summary of events and findings related to their involvement in the program so the board may investigate and possibly discipline them. And third, take other action that is provided for within the procedures contained within the contract. Next slide, please. As a condition of joining the program, participants must authorize the PHWP to release information to the board when required by law or as authorized by their written agreement. This section also includes a requirement for the PHWP to make reports when the participant fails to comply with their agreement or when the program believes the licensee cannot practice safely. Similarly, the program must inform the board of someone who has not entered the program that the PHWP determines is unable to practice safely. The section includes a requirement for those within the jurisdiction of the board who are practicing to inform the board within 3 days of the date they withdraw or are terminated from the program without successful completion. Next slide, please. There is authority for those who previously withdrew or were terminated without successful completion to re-enter the program, provided both the program and the board consent. Finally, the section in subdivision K makes clear that the board retains authority to discipline any current or former participant and may also order them to undergo a competency evaluation under Business and Professional Code section 820. Next slide. Moving to 2340.10, one key factor in the proposal is, and these programs in general, is a written agreement between the program and the participant. This section requires such an agreement and provides for the minimum components of that agreement, which includes the various mandatory conditions and procedures that the participant must meet to remain in the program. Compliance with any applicable probation order is included for those referred to the program via the board's disciplinary process. Next slide, please. There are 10 such minimum requirements for this written agreement, and others may be added based upon the circumstances surrounding any given participant. Next slide, please. Section 2340.12, the records that would be created related to the program are understandably highly sensitive. These, for example, could include those that relate to the care and treatment of a participant or to the board's deliberations and discipline. Therefore, the section broadly provides for the confidentiality of those records, except as otherwise provided here. The board uses such records in disciplinary cases that are then subject to the discovery process by an accused licensee. Next slide. This section is intended to help protect those involved in and around the program from costly and time-consuming civil litigation, which could originate from a current or former program participant. Therefore, this section provides a shield to those who report information or take other action in good faith. This section includes a suggestion to the court to impose sanctions on program participants and their attorneys who make claims that are not in good faith and are without a reasonable objective and or substantive grounds. Next slide. Excuse me here. This section, 2340.16, states that the board is authorized to establish one or more committees to help the board carry out its responsibilities related to the program. If the board chooses, then this section prescribes how those individuals would be appointed, including the length of their term on any committee. It states that there should be at least 3 members to a committee, and those members shall not be affiliated with a PHWP or its contractors. Next slide. On this slide here, we see the qualifications for appointment, which is detailed in subdivision C of this section. Next slide. Subdivisions E and F of the section describe the committee's authority to meet in closed session to discuss certain sensitive matters and provide for per diem and expensement reimbursement for the members. Next slide. 2340.18 authorizes but does not mandate the use of these advisory committees. And this slide includes a little bit of information about their role, their potential role. Next slide. In addition to these various possible duties for the committee, the section as well provides for civil damage immunity related to their good faith actions. Next slide. Section 2340.20 includes some language from the existing law, which already establishes a fund for the purpose of this program that's currently being unused. It includes the existing prohibition that funds collected are not to be used for the cost for participants to be in the program. If this were to become legislation or be introduced and funding is identified, I would expect this section to be changed quite a bit. Next slide, please. 2340.22. To help support the effectiveness of the program, this proposal includes a requirement for licensees to report either to the program or the board the name and contact information of another licensee if the reporter believes in good faith that their colleague may have a condition that impacts their ability to practice in a safe, competent, and professional manner. The name of the reporting licensee would be kept confidential unless they give permission to share it or disclosure is otherwise required by law. Next slide. Existing law generally states that statutes that may apply to the Medical Board of California will also apply to the Osteopathic Medical Board, or OMBC. OMBC has their own program, therefore we felt it helpful to add a section to make it clear to the legislature and others that this proposal is not intended to impact them. Next slide. So I thought it might be good to do a brief contrast between what's in current statute and what's in the proposal before the members. Again, we're here today because the board was dissatisfied with current law and wanted to develop a legislative proposal that's aligned to establish a program that's aligned with best practices. So these next few slides will highlight some of those key differences. This proposal, one, covers any impairing condition, not just substance abuse, and is available to far more individuals, notably those who are future licensees and registrants of the board. The proposal suggests handling voluntary participants differently than those who are compelled to enter the program through board discipline. And it contemplates the opportunity to have a longer term contract than would otherwise be available under current law. Next slide. Very importantly, those who are alleged to have harmed patients or engaged in sexual misconduct would not be eligible to enter the program in lieu of discipline. This proposal does not place the burden of paying only on the shoulders of participants, and it has stronger confidentiality provisions than current law. Next slide. This proposal also includes civil liability protections, the possible role of advisory committees, and mandatory reports of impaired licensees from their colleagues. Those are some of the key features that sets this proposal apart from existing statute. It is the desire with this proposal that we will lay the foundation needed to build an effective program that promotes consumer protection and was stated very clearly by Ms. Torres will actually be used by the intended participants. Next slide, please. Before we go to questions, and I turn it back to the president. One, thank you for your patience with the presentation. Again, the recommendation in the paper is to direct staff to find a legislator to author this proposal and to authorize the president and the vice president to work with the board staff and stakeholders to move forward through the legislative process. Again, today is about pouring a foundation for a future program. As you saw in the earlier slide, there are some major steps that lie ahead beyond changing statute that will take quite a while for us to complete. If it is the will of the board to move forward and we can secure an author, the board would see this as a legislative item on future board meeting agendas, where we would update the board on our progress, including any amendments that are made. If the board takes this step today, it will be very important to understand the board's sentiment on what aspects of this proposal are must-haves that are non-negotiables. I raise this point because we will expect to receive requests and, frankly, demands for changes to this proposal if it's going to move forward. And therefore, it's vital that we have your direction and the sentiment of the board so that way we know how to react to those requests and demands. One of my key takeaways from the board's May discussion is that the board is not willing to settle for anything other than an excellent program. So therefore, understanding what the boundaries of what constitutes excellence for the board is necessary and critical, so that way we can attempt to marshal the legislative and stakeholder support that will be necessary to enact a bill, so that way we do not fall short of the board's expectations. Again, thank you all for your patience. I want to extend and acknowledge an additional thanks and appreciation to Ms. Webb. We would not be here with this proposal if it were not for her time and diligence and thoughtfulness. When we get to questions, Mr. Varghese, Ms. Webb, and myself will be happy to respond. And I'll turn it back to you, Madam President.
Thank you, Mr. Bone, for that great presentation. Thank you also to the members of the task force who have assisted in having this proposal work its way through our process. If the board is okay with it, I think I'd like to go to public comments first so that we can hear from the folks that want to comment, and then we can have everything on the table before we deliberate and have a discussion. So we'll go ahead with that. Are there members of the public in the room who would like to comment? Welcome.
Good morning, board members. My name is Marcus Friedman, Administrative Director for the Consumer Protection Policy Center, or CPPC, at the University of San Diego School of Law. CPPC, previously known as the Center for Public Interest Law, is a nonprofit, nonpartisan academic and advisory center at USD School of Law. We have examined and critiqued California's regulatory agencies for over 40 years. I previously testified on the May 24th board meeting about our previous administrative director, Julie Felmuth, who investigated and reviewed the medical board's substance abusing monitoring program in 2004. The program was audited 5 times in its 24-year existence. It failed all 5 audits. The most common problems were understaffing, lack of resource, inability to detect relapses, and the board's failure to adequately oversee the program. After the 5th audit, the board voted unanimously to end the program in July of 2007, and it was abolished on June 30th, 2008. At the same May 24th board meeting, this board voted to end the flawed wellness program rulemaking. This draft legislation is very similar to the previous rulemaking that was voted down. On November 1st, CPPC submitted extensive written testimony identifying many issues with the draft, including the following. 1, it does not provide the board oversight to ensure that your enforcement program is promptly receiving notice of relapse or noncompliance. 2, the draft exempts any new program from the uniform standards with no explanation for why that is appropriate. 3, it requires the board to contract with a nonprofit to the exclusion of experienced for-profit vendors. 4, it introduces mystifying abnormalities into the state contracting process. And 5, it fails to identify funding sources for the program. If you are not aware of these issues, please read our written comment. Earlier this year, Les Lombardo, the most recent enforcement monitor, detailed 4 areas of concern for the Medical Board of California. It included 1, serious injury or death complaints being closed without investigation and problems with the complaint tracking system project. 2, lack of collaboration between the health quality enforcement prosecution and the investigators that impact efficient, effective, and timely adjudication, as well as problematic medical expert analysis. 3, physician and surgeon demographic data analysis. And 4, additional enforcement program issues such as critical issues of program funding shortages and complaint outreach interviews. A physician health and wellness program is not included in the list of issues this board currently faces. A wellness program is designed to benefit doctors first and only benefits patients and the public as an auxiliary side effect if the program is successful. Before I was administrator of CPPC, I was a criminal prosecutor for nearly 2 years. I handled a multitude of DUI cases. It was a common practice to require defendants to seek treatment with Alcoholics Anonymous, Narcotics Anonymous, or other residential treatment programs as part of their probation. If the defendant failed to provide proof or skipped treatment, the court would impose harsher terms or terminate the probation unsuccessfully and impose custody time. The courts nor the prosecuting office they were in charge of their rehabilitation programs, but rather held them accountable if they failed to provide proof of their treatment. Of course, the circumstances here are different, but the enforcement methods should be the same. It is your primary responsibility to protect the public from substance abusing physicians by enforcement, not to create programs for doctors to assist them in the alcohol or drug recovery, especially if they are a danger to the public.
Please conclude.
CPPC urges this board to abandon its efforts to create a new wellness program. There are many other issues this board should focus on, such as licensing, investigations, and enforcement. CPC encourages this board to reject the proposed program indefinitely. Thank you.
Thank you for your public comment. Other commenters in the room?
Hello. Hi, my name is Kimberly Turpin. I am from Los Angeles and I'm a volunteer with Consumer Watchdog. I really want to believe that our advocacy makes a difference with this board. I really want to believe that you hear us and that you are here to make a difference to save lives with us. This legislative proposal is telling the public that you don't care how many of our family members die or how many of us are traumatized with lifelong harm. I became an advocate after I experienced medical battery during the delivery of my son. I will never be the same, but also I survived. I am here to advocate to save other mothers' lives. Why are you here? You accepted appointments to serve on a board whose mission is to protect consumers. Yet, this legislative proposal does not protect us. It protects substance abusing physicians. It protects their livelihoods over our families' lives. If I should get a DUI or if I should decide to turn to drugs, I should have to pay the consequences like everybody else. We all have to pay for our consequences. Why shouldn't doctors? I join my fellow team members and urge you to vote no on the legislative proposal. Show us that you are here to meet your mission of protecting consumers. Save our families and save the uniform standards. Thank you.
Thank you for your public comment. Other commenters in the room?
Oh, thank you. Hello, my name is Lucas Evanson, and I'm speaking on behalf of the California Medical Association. CMA would like to begin by reiterating our appreciation to the board and board staff for the work done up until this point. We also want to thank President Lawson for her framing comments, which we believe accurately capture the current landscape. As we've stated in our letter included in today's packet, CMA views the proposal as one which recognizes that impairment is not a personal failing and seeks to provide meaningful ways for licensees of the board to access help in the furtherance of consumer protection in alignment with its mission to protect healthcare, consumers, and prevent harm. This program represents a critical opportunity because the board currently has no tools at its disposal for licensees with health conditions that could impair their ability to practice medicine before harm occurs. At its two most recent sunset review hearings before the legislators expressed concerns over the reactive way in which the board operates. CMA recognizes that in general, there is not a lot the board can do about that. The board's work is by nature very reactive. However, the program contained within this proposal would allow the board to proactively provide a mechanism to prevent harm in a way that has been proven across the country. CMA asks the board enthusiastically to adopt the motion recommended by staff to continue through the legislative process. We appreciate that the language we're discussing today incorporates concepts from the national best practices. We look forward to continuing to work with the board and board staff on the proposal. Thank you.
Thank you for your public comment. Other commenters in the room? Oop. Welcome.
Hello, my name is Christine Bildrain. I'm from Reseda and I'm a volunteer with Consumer Watchdog. I'm a mother first and foremost. My child had a condition that required him to receive medical care 3 times a week. This meant that I had to rely on the best practices of doctors and other providers to make the best decisions for my son. That didn't happen. I came to this board because you have a mission to protect consumers, but then I read that you are willing to give up tools and standards that the legislator gave you to protect my children. How is your willingness to protect substance abusing doctors and take away any consequences they have now if they fail any part of the program going to keep my children safe? Believe me, I worked hard to protect my son and keep him safe. I filed complaints when protocols were not followed. I reported them. I didn't do this just to protect my child. I did this also to protect all the children in that unit. I became an advocate for my child because I was willing to do whatever it took to protect my child. Yet my child still died. He was patient dumped from a Los Angeles hospital, and his doctors agreed to it. He died 3 weeks after he was patient dumped. Why are you not willing to protect our children? Why are you putting the wants and needs of substance abusing doctors before us? I urge you to vote no on the legislative proposal. You have the opportunity to meet your mission and protect families. Save our children and save the uniform standards. Thank you.
Thank you for your public comment. Other commenters in the room?
This is Naya. Yes.
Good morning. My name is Jesus Velasquez. This is my mother, and this is my father. We are from Gardena, and we are volunteers with Consumer Watchdog. I am really shocked that you would even consider taking away consequences for substance abusing doctors. Why? Do you think that that is protecting them? I know you cannot think you're protecting us. I was told that your board's mission is to protect consumers. How are you protecting our families? We shared part of my brother Snyder's story with you yesterday. He was a 13-year-old boy that loved to skateboard. He loved to go camping. He was in remission and back to his old self. We were so happy to have him back and well. Please understand that I am his brother, but Snyder was like a son to me. We showed you a picture of Snyder yesterday. Now we want you to see what happened to my brother under his doctor's care. My brother was suffering and dying right before my family's eyes. The doctors told us that they didn't know what was wrong and they didn't know what to do. My mom begged them to transfer him to another hospital for a higher level of care, and they refused. Look at his picture. My brother was tortured. No one deserves this. No child should ever have to be put through this. We learned this week in the medical records that my brother was listed as an experimental subject. Would you want your child to be used as an experimental subject? We trusted the doctors. We trusted the system. We trusted that they would give my brother the care that he needed, not to use him as research. We are not the only family. There are others. We are dying here. Our children are dying, and you are worrying about substance abusing doctors and whether they would have to get disciplined for dropping out of treatment or cheating drug tests. You have bigger issues sitting right here before you. You have a mission to protect our children and our families. We urge you to vote no on the legislative proposal. Your vote will show us that you are here to protect our families or protect substance abusing doctors. I want you guys to touch your heart and to realize the potential and the harm that you guys will be causing families if you guys vote yes on this. Because you guys are not going to want You guys are not going to be the ones that pay the consequences, but it's going to be the families that we put our faith in the system and in the doctors that you guys are going to do the correct thing and that you guys are going to put lives first. All you guys took an oath to protect the lives of your patients. How could you possibly think that voting yes on this is going to help patients? That is not helping us. That is helping them. We urge you to protect our families, to honor the oath that all you guys made, and to hold those accountable for that are addicted to drug abuse and alcohol. These are my brother's pictures.
Pedimos ayuda y nadie nos ayudó.
We begged for help and no one helped us.
Cambio de otro hospital, nadie nos ayudó.
If doctors that are in their sixth sentence are able to make mistakes like this, what do you guys think is going to happen if you guys are helping drug abusing doctors?
Récord médico dicen que fue experimental.
Please conclude.
I will now be translating for another mother. I am Teresa Lopez, and I am from Torrance. I am a volunteer with Consumer Watchdogs. I can't understand why this board is so concerned with giving substance abusing doctors special rights, while we, the public, have no special rights if we abuse drugs or alcohol. We don't even have rights when we take care of our children to a hospital for care and for help. My son Christian died at the same hospital as Snyder. He died the same way. I was told by the doctors that he had to have a bone marrow transplant or he would die. They pressured me and told me that my son would die. Of course, I am going to do whatever it takes to save my son's life. 6 days after the transplant, my son started having the same problems as Snyder. Look at his picture. My son was healthy and happy. Look at his picture of him dying. No child should have to endure this, and no parent should have to be lied to and beg for help and left to watch their child die in front of them because no one was willing to help them. Now you, the board that is supposed to ensure consumer protection, wants to take more steps to put our children at risk. With this legislative proposal, you aren't helping anyone. I'm asking you to vote no on the legislative proposal to save our children and to honor the uniform.
Él entró muy alegre y contento para recibir su trasplante.
He was really happy when he checked in to get a transplant. He was happy in the home. He wasn't sick.
Pero lo triste es de que ahí
But the sad thing is,
es de que lo torturaron mucho ya después de todo lo que pasó.
he suffered a lot.
Yo le
He
pude
was
buscar
he was under very unhygienic conditions in the hospital. He had a blood clot in his mouth, and I had to be the one that removed the blood clot because nobody was helping me.
la boquita porque ellos,
I washed his mouth because nobody helped me.
ya cuando ellos, yo sentí que mi niño
When I noticed that my son was tired,
medicamento más fuerte,
they kept on juicing him up with more drugs, and he passed away. I want you guys to look at this picture.
historia de Snyder.
It is the same story as my brother.
Una célula en un billón de billones.
One cell within the millions.
Si no le haces el trasplante en 3 meses, tu hijo muere.
Your son's gonna die in 3 months if you don't go on with this.
Nos hicieron firmar papeles en inglés.
We all signed documents in English.
No nos dejaron tomar fotos.
They didn't let us take pictures of the documents that we were signing.
No tuvimos un traductor que nos traduciera.
The translator did not do his job properly.
Que no récord de nuestros hijos dice que fueron hombres experimentales.
We urge you to vote no on this legislative proposal. That is helping them, and that is not helping us. You guys are here to help us, the public, not them.
Habemos muchas mamás con la misma
There's a
situación.
lot of us with the same situation.
Todos nuestros hijos murieron.
All our kids died. Thank you for your
Situaciones
time.
catastróficas. Ningún niño merece morir así.
No child deserves to lie like this.
Tenían esperanza de vida. Nos engañaron.
We were lied to.
Thank you.
Thank you for joining us and to all of you for those public comments. Additional commenters in the room?
Hello,
My name is Leslie Saldana. I am a volunteer and consumer watchdogs. I am here to try to make an impact to convince you all to vote no. Everyone, regardless of their job status, should be able to face consequences of drug or alcohol abuse. I would love to know that there is someone on our side and will stand with all the families that have suffered the negligence of doctors. My baby brother Ricardo was only 15. Excuse me. He isn't here to speak for himself, so I am here to speak for him. As an older sister, because I told him in his deathbed that regardless of what happens to him, I will be here to protect him. My mother was told that my brother was going to go to school by this August, and we were lied to. No mother, no sister should ever to see their brother die. We were told he was going to survive. The doctors, in their own words, told my mother that they were going to use my brother as a lab rat for experiments. And that is not right. No doctors, nobody, no mother, no sister, no father should ever have to bury their son. No coffin should be so little, more than less white. My brother was in a vegetable state when by the time we took him to the doctors. We were only supposed to go in for an appointment, just an appointment. My little brother did not want me to go. He wanted me to go, but I didn't know that that appointment was going to make us have so much pain because my brother ended up leaving in a body bag. I walked in with my brother and I walked out without him. My brother was healthy and he was happy to get his appointment over with. He urinated himself and the doctors refused to clean him. No sister, no family should ever see their brother suffer. I'm hoping that you guys vote no on this so that doctors could be held accountable if they are drugged up or they are an alcoholic. Nobody should ever have to go through this pain. And I'm sorry that my tears have inflicted my speech and took some of my time. I do apologize for that. But it does hurt to see that my little brother had to suffer because these doctors were not alcoholics. They were not on drug abuse. But imagine what a doctor would do to a family if they were on drugs, if they were alcoholics. Imagine what that could do. Just imagine if these are your sons, your parents. You guys will not want to suffer the way how these families are suffering. It is ugly. It is horrible. So horrible. I didn't eat for 2 months straight.
Conclude.
I could go? Or I continue or I go?
Just please conclude your comments.
Okay. So I'm hoping that you guys vote no so that nobody has to go through this pain that we all have suffered. Please, please don't make no other family suffer. These doctors should not have to be, these doctors should be held accountable if they are alcoholics or going through something, maybe mental, they should be held accountable. Because them being on alcoholics or being on drugs is not an excuse for them to try to work with our loved ones' lives like that at all. Please. Thank you. I'm so sorry for my tears, by the way. Sorry.
Please don't apologize. Thank you for coming and thank you for your public comments.
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I really hope you listen to these families. There's families here today that their loved ones just died a month ago, but they were courageous enough and brave enough to come before this board. We want to go forward, not backwards, especially when you've dedicated 17 years of your life to resolve a tragedy that cut short an inspiring young man's life. That's partially what's so wrong with this issue. It's the gentleman versus the substance abusing doctor. In this case, people tend to say that the good guy always loses. In this case, the good guy died, and the substance abusing physician continued to live to harm others because his livelihood was more important than Lloyd Montserrat's life. This issue is no longer about whether Californians have died due to substance abusing physicians. We know they continue to do so. We resolved that issue in 2007. In 2007, a board like yours had the courage to stand up against a mighty force that insisted that a faulty program should continue by any means. Now it's your turn to show the public what you are made of. That you are courageous enough to stand up for the public and recognize what is right versus what is wrong. It took 8 years for this board to come forward with regulations to bring this program back. Yet this board decided to throw away regulations and start all over again. But this time to stand on the side of what's wrong. You decided that you know better than the legislature, and you decided to undo the legislature's work, the Substance Abuse Coordination Committee's work, and 16 years of advocacy. You've decided to give up the tools that the legislature gave you and have decided that substance abusing physicians should have no consequences when they violate this program. You've decided to throw away the uniform standards, standards that you know have only saved patients' lives, but also the lives of a few substance abusing physicians. But there's more. You've decided to attempt to enter into a multi-year contract with a vendor without having to obtain approval from anyone. Try telling these families that stand behind me and the many families on WebEx that the mighty force, the elephant in the room, is more important than their families, than their remaining children. Withdraw this legislative proposal. This issue is a fundamental issue in healthcare. When you move forward with a program, you need to move forward with a program that adheres to uniform standards. We aren't going anywhere. We will just keep coming back with more advocates because our family members are dying every single day from tragically negligent deaths. You are appointed by the governor, the Speaker of the Assembly, and the Senate Rules Committee to protect Californians, not the profession. Thank you.
Thank you for your public comment. Other commenters in the room? Please watch your step. It's not.
Good morning, ladies and gentlemen of the Medical Board. My name is Dylan Izatseta. I'm from Moreno Valley and a volunteer with Consumer Watchdog. I'm a certified substance abuse counselor with a degree in alcohol and drug studies. I'm also a recovering alcoholic of 16 years. I have worked in substance abuse treatment for 10 years. Regardless of my capacity as an employee in the organization, I am considered a healthcare provider. The expectation of me is to be abstinent of all mind-altering substances for the duration of my employment. Why do you not have the same expectations of doctors? You currently have uniform standards in place that will help keep doctors on their sobriety track. You have standards that provide consequences if a provider fails part of the program. In life, we all have consequences. The problem is that you are willing to put our lives on the line to protect substance abusing doctors, but the problem is you're not protecting them, you're enabling them to continue to abuse substances. My fellow team members and I know quite a bit about unsafe care. My daughter died due to medical negligence. I did everything in my power to care for her and nurture her. But my doctor did not conduct the tests that he signed on to an acknowledgement that I needed. I was having complications, and those tests would have revealed that. Instead, he did nothing, and my daughter died. This is a fundamental issue for basic safe healthcare. There is no tolerance in my field of work putting a client in any form of danger. If I were to practice with an altering mind, I would be terminated from my employment immediately. In most cases, substance abuse facilities require 2 years of sobriety to be eligible for hire if one identifies as an alcoholic or an addict. Doctors are supposed to be role models in our healthcare system. Currently, this is not the case, and patients are being endangered every day by doctors who choose to work impaired or untreated mental health disorders. Not only are the patients impacted, but their families also suffer as well. A doctor's first code of ethics is to do no harm. That is difficult to accomplish with substance abuse problems. You also have a code to follow, and that is to ensure consumer protection. Save our families, save the uniform standards. Thank you so much for your time.
Thank you for your comments. Are there members of the public in the room who wish to comment? Okay, seeing none, Sean, let's go to the WebEx, please.
Anyone wish to make a public comment online? You can do so by pressing *3 if you're on a call-in-only line, using the hand-raising feature, or just typing you'd like to make a public comment in the Q&A window. First up here, Christy Waters. Let me go ahead and send you that request. And if you have your hand up, we'll still see it here. So if you toggle up and down, it just moves you to the end of the queue. Looks like your line's open.
Good morning. Can you hear me?
We can. Please go ahead.
So I appreciate the opportunity to be able to speak. I am an addiction medicine and psychiatrist for more than 30 years here in California. I'm representing the California Society of Addiction Medicine, also known as CSAM. It's a medical specialty society with more than 700 physician leaders and addiction experts in California. Our first priority is consumer safety through evidence-based treatment. We have advocated consistently over the years for a physician health program that aligns with clinical experience and takes advantage of the experience amassed by programs in other states. We support the medical board's efforts in this new direction. We believe that a properly structured and administered statewide physician health and wellness program can actually amplify the Medical Board of California's priority for consumer safety. We know that bringing a physician into a program with early identification and early intervention is what makes the difference. We support the voluntary evaluation, treatment, and monitoring provision that allows the board to refer a licensee to the program if an investigation finds that the conduct may be the result of an impairing or potentially impairing condition. We support the requirement that persons carrying out roles in the program have experience in treatment of healthcare professionals. There have been many studies taking a look at the unique aspects, intervention and treatment for specific groups, and this is particularly true for medical professionals. CSAM does have concerns about aspects of the proposal, including confidentiality provisions, funding, and which groups are included. Those discussions can happen later, but today it's a priority to support the Medical Board of California's decision to move forward with a legislative effort to establish a physician health and wellness program. CSAM supports such a program that is evidence-based and, most importantly, protects the public, which we believe is also a priority for the Medical Board. Thank you.
Thank you for your public comment. Next here, we're going to Xavier De Leon. Should be receiving that prompt.
You guys hear me?
We can. Please go ahead.
Hello, I'm Xavier De Leon. I'm an advocate with Consumer Watchdog from Bakersfield, California. I became an advocate when I was when I was faced with the most devastating day of my life, when my son Malachi took his last breaths in my arms, having only lived 18 hours. I hope you guys never have to go through what I did. I don't want any other father to endure the same pain that I have to carry every day. You guys shouldn't want any other father to experience what I did either. You have told us over and over that the consumer protection is paramount to this board, but the legislative proposal does not prove that. It proves that you put a substance abusing doctor's profession over our babies' lives. I'm curious as to why you all chose to accept an appointment to this board. Was your intent to ensure that that more of our babies die and more families are harmed? Because this proposal allows this program and their participants to do whatever they want. There are no consequences for a minor or major violation of this program. A substance abusing doctor can fail a drug test, avoid a drug test, or cheat a test, and the program doesn't have to report it to you. You are giving this program the ability to advocate on behalf of the substance abusing doctor with their workplace. So I'm assuming it is fine with you for a substance abusing doctor to practice under the influence, and you don't want to know. We need to know. If someone should know, this board should know. We urge you to vote no on this legislative proposal. Save our babies, save the uniform standards. Thank you.
Thank you for your public comment. Next up here, we have Denise Johnson. Denise, you should be receiving that prompt.
President, members of the board, my name is Denise Johnson. I am from Tracy and a volunteer with Consumer Watchdog. I am so disillusioned. I thought we had finally gotten to a point where you started listening to the public and understanding that we are stakeholders in this system. We're the ones that are dying. It is we parents that are having to bury our children. My son died. He fought so hard to live. He had survived brain cancer only to die due to denial of care and an infection left untreated. Do you understand? He didn't have to die. My son Richard should be sitting next to me at Thanksgiving. That will never be. Now I'm left here to fight for other families in my son's honor and memory. You're doing a great job protecting the substance abusing doctors, but who's protecting us? You want to give a multi-year contract to a vendor with no approval from anyone. You want the program to advocate on behalf of the program participants so they can avoid discipline with this board. You want the program to advocate for the substance abusing doctors with their workplaces. Why? If a doctor is found under the influence and or relapsing, you want the program to convince the medical director to not report to the board. Again, what about our families? Can you hear us? How many of our children have to die before you hear us? We aren't going anywhere. Your actions show that you don't value California families, but we do. We will fight this till the end. We urge you to vote no on the legislative proposal. Show us that you are here to meet your mission of consumer protection. Save our children. Save the uniform standards. Thank you for your time.
Thank you for your public comment. Next here, we have Michael Ulrich. Should be receiving that prompt. Good morning, Michael. Your line's open.
Hello, everyone. I'd like to thank the board and community members. My name is Dr. Michael Ulrich. I'm an internist in Riverside County, a husband and a father. I'm a patient, and I'm a doctor taking care of about 6,000 patients in Riverside County. here on behalf of the American College of Physicians to talk about this proposal. I want to let the members of the public know that, it's not common knowledge, but about 1 in 4 of your doctors may be suffering from a mental health issue at some point during their career. Some say 2 out of 4. And this is not necessarily disqualifying, does not mean that they don't have good intentions. It's just, we are human beings. We are your sons and daughters. We want to do what's best for people. And, but sometimes we fall on hard times. And, I understand that the public has concerns about a physician wellness program, but you should know that, nationally, we are only one of 2 states that do not have such a program. I myself was on the front line of the COVID pandemic, at great risk to my own personal health and to the health of my family. Yet when my community called on me to serve, I answered the call and met those challenges and protected patients. And really, the current status quo is not protecting patients. We are driving our doctors with mental health issues underground, and we are discouraging them from reporting to the medical board. And there is no pathway currently. The current, like I said, we are only one of 2 states that do that. What I want really is to separate, the public, to separate in their minds people who have health issues from those who are engaged in criminal behavior. We do not want doctors practicing who are engaged in criminal behavior, but doctors who have health issues, we want to support them so they can get back to practice in their communities. I urge the board to adopt this legislation. Oh, yes. In the interest of protecting our patients, I'm here to protect my patients. I thank you for your time, and I yield the rest.
Thank you for your public comment. Next up here, we have Marion Hollingsworth. Marion, you should be receiving that prompt.
Okay, can you hear me?
We can, Marion. Please go
Okay,
ahead.
thank you. Good morning. My name is Marion Hollingsworth, patient safety advocate. You do know that any doctor can already seek out help in a rehab without you even knowing it. A doctor can just say he's taking a European vacation for a month and go into rehab instead. They don't have to go into your program. I have issues with this wellness program and how it shelters doctors instead of protecting patients, and in doing so, reduces the authority of the board, making it complicit. The first is 2340.12, which is confidentiality. According to the section, doctor records can't even be subpoenaed. This really puts doctors on a higher pedestal, making them above the law and out of the reach of the medical board. The next is 2340.12. I'm sorry, that was a different one. I'll keep going, which provides immunity for licensees who report a suspected addicted colleague. This really opens up a Pandora's box for lying, for getting competitors in trouble. Some of you have never experienced a doctor lying, but I have. I've had doctors lie to my face about my father's drugging, and I have seen them lie under oath. One even falsified a DNR. They lie regularly. I have no doubt that this law will be abused. And then there's 2340.18, the advisory committee. So basically, people who aren't on the board are going to tell the executive director which doctor should be diverted to the program and which should be disciplined. So basically, usurping the authority of the executive director and the board. I would hope any legislation would enhance and increase the authority of the board and not undermine it, particularly when it comes to patient safety. Can you define reasonably safe? What does that even mean? A doctor weaving back and forth in the OR but still staying on his feet? A blood alcohol content of less than 0.24? And why throw out the uniform standards which have helped protect countless patients from addicted doctors? You keep saying that this wellness program is about patient safety, when in fact it's more about doctor protection. You keep moving farther away from that goal and your own mission statement to protect patients. This board failed with the previous program, so why should we trust you now? It's like trusting an unfaithful spouse. We have doubts that you will do the right thing. I hope you will vote no for this wellness program. Thank you.
Thank you for your public comment. Next up here, we have Susan Shinazy. Should be receiving that prompt. Morning, Susan. Your line's
Hello.
open.
Hi, my name's Susan Shanese. I'm from Bakersfield. I'm a co-founder of Hospital Watchdog and a volunteer with Consumer Watchdog. I'm also a nurse who was harmed while on duty. I required surgery for my injuries. The surgeon made life-threatening errors during my surgery, and I required a double lung transplant due to the surgical errors. The suffering has been tremendous. I've also watched family members die a horrific death due to medical negligence, and I have investigated many cases of fatal medical errors. As board members, you know the impact of medical harm, and you know it's increasing. We all know that. Substance abuse is one of many reasons for this, and real solutions should be the highest of priorities. Strengthening, not weakening solutions should be the highest priority. We need to all treat all lives as equally important. Otherwise, it appears as classism, and classism has no place in medicine. I urge you to vote no on the legislative proposal. Please choose to save lives by saving the uniform standards. Thank you very much. I do know you have a tough job, and I know you're up to it. Thank you.
Thank you for your public comment. Next here we have Alka Airy.
Hello, can you hear me?
We can. Please go ahead.
Oh, okay, perfect. Hi, I'm Alka Airy, and I'm from San Francisco. I'm also a volunteer with Consumer Watchdog. I had so much hope for this board and with what we were accomplishing together. It seemed that the board was finally listening to the public's concerns, but then I read the changes that you want to make with this legislative proposal and realized you are still prioritizing the livelihoods of physicians over patient safety. This is an inflection point. Is this board going to have the courage to say, no, we reject this proposal? It's no longer good enough to tell the public that consumer protection is paramount to this board. You need to show us through your actions, and that means rejecting this proposal. My older sister was a research scientist. She helped develop many FDA-approved drugs and later focused on rare genetic diseases in children. She died due to medical negligence. An anesthesia error led to a massive pulmonary aspiration. She needed a double lung transplant, but wasn't listed in time to receive one, and she died at the age of 47. Her death was entirely preventable. She made a difference in this world, but her life meant nothing to the physicians in charge of her care. Those physicians essentially prioritized their livelihoods over hers, and this board let the negligent physicians get away with it. Unfortunately, my sister's ordeal wasn't isolated. There are thousands of patients harmed by negligence each year with little to no consequences. This proposal is taking us in the wrong direction to a program that is far worse than one that a brave board voted to terminate many years ago. At least those board members had the courage to say no then. I shouldn't have to state the obvious, but this board exists to protect the public. Rejecting this proposal prioritizes the concerns of the public. Do you have the courage to say no to this proposal and support what is in the best interest of the public? As I said, this is an inflection point for this board and its commitment to public safety. This proposal is dangerous. This program would help participants avoid discipline with this board and help physicians hide their substance abuse issues from their patients. Show us who has the courage to reject this legislative proposal. I urge you to vote no. Please save our families and save the uniform standards. Thank you.
Thank you for your public comment. Next here we have Maria Ibarra Navarrete. Should be receiving that prompt.
Maria Ibarra Navarrete. I am from San Jose. I'm a volunteer with Consumers Watchdog.
Please explain to us why substance abusing doctors' livelihood is more important than our lives. We are right at the point of approving regulations to bring back PHWP program that followed the uniform standards as the law required you to, but then you did a complete turnaround. It took this board 8 years to come forward with regulations, and you throw them away to seek new legislation that will overturn 2 laws. Why? Why is it a problem for this program to follow the uniform standards? Why do you want to give away the tools that the legislator gave you to protect families? The legislator tried to provide a balance to help you meet your mission to protect families, and you want to get rid of it? You say that consumer protection is paramount, but your actions speak otherwise. My 29-year-old disabled brother died due to extreme negligence by not one, but by 2 doctors. When he was finally taken to a hospital, they didn't follow the sepsis protocol and didn't start treatment immediately. They didn't even know where he was. They lost him. They finally found him 10 minutes later, unconscious on the bathroom floor, not breathing. My brother died at 29. We can no longer accept you telling us that you are here to protect consumers. You need to show us. We urge you to vote no on the legislative proposal. Show us that you accepted this appointment as a board member to meet your mission of protecting consumers. As you vote on this life-changing decision that affects all Californians, including yourself, ask yourself, how would you like a doctor that is under the influence of drugs and alcohol to provide medical care to your children, your spouse, your parents, your sibling, but most of all, keep in mind those that have lost their lives due to medical negligence, especially at the hands of doctors that provided medical care while they were under the influence of substances. Save our families, save the uniform standards. Thank you.
Thank you for your public comment. Next request here is for David Granavetter. Should be receiving that prompt.
You hear me?
We can, David. Please go ahead.
Okay, excellent. Okay. So good morning, members of the board and members of the public. I appreciate the framing, comments, and discussions so far. And my heart also goes out to those that have tragically lost loved ones. My name's Dave Granavetter. I've been practicing in California as a physician for over 35 years, with 22 of those devoted to addiction medicine. I've also held leadership roles in physician well-being for more than 2 decades, and I'm proud to be a physician in long-term recovery from the disease of addiction. I also successfully completed 5 years of intensive monitoring in the prior PHP diversion program. Now, these experiences give me a unique perspective on the critical need for a well-structured physician health and wellness program in our state. I previously offered comments at the interested parties meeting on October 24th and in writing regarding the proposed language, and I won't repeat those here today, but I do want to address a key point which has been repeatedly raised by others in opposition to the proposed program and language. While I honor, I practice, and I wholeheartedly agree with the need to prioritize patient safety, I believe that the proposed PHP and its regulatory framework represents the best pathway to achieve this goal by offering a confidential resource for physicians to seek help before their issues escalate to significant impairment or patient harm. The PHP serves as a proactive model of public protection. Physicians who are in the early stages of struggling with substance use or mental health conditions can receive comprehensive evaluation, treatment, and long-term monitoring, ensuring they maintain the ability to practice safely and effectively. This approach not only mitigates the risk of potential harm, but also creates a culture of accountability, a culture of safety, and instead of waiting for harm to occur, the PHP addresses the root causes early, helping physicians recover while protecting the public. Programs like this have been immensely successful in other states demonstrating that confidentiality and patient safety are not mutually exclusive. Rather, they are complementary goals that strengthen trust in our profession and safeguard our community. So I urge the board to move forward with the proposed program. And this framework is not only a step forward for physician health, but a vital safeguard for patient safety and public trust in healthcare. Thank you for your time and for the opportunity to share my perspective with you today.
Thank you for your public comment. Next here is Tracy Dominguez.
Hello?
Come on, Tracy.
Okay, hi. I am Tracy Dominguez. I am from Bakersfield and I am a volunteer with Consumer Watchdog. This legislative proposal is dangerous. It is dangerous for families and it's dangerous for substance abuse, and it is dangerous for substance abuse doctors. I want what is best for our families, and you should also want that. You are voting on a legislative proposal that will have this program talk to the workplace for substance abuse doctors to advocate for them. When I took my daughter to our local hospital, no one told me that her doctor had lost hospital privileges at 2 different hospitals. There were no disciplinary actions on your website showing that you had taken action on the doctor who lost his hospital privileges at 2 different hospitals. Now you want to take this step further, and you want a program that helps substance abuse doctors continue to work, no matter what their condition is. How do our families fit into this picture? My daughter died from undiagnosed preeclampsia. She was ignored by not one doctor, but 2 OBGYNs. She did everything she could to get help for her and her baby, but no doctor would help her. My daughter died, and my grandson had to endure a postmortem C-section, only to have to endure extreme negligent care. He only lived for 18 hours. 3 doctors failed my grandson. Now you want to vote on a legislative proposal that will strip you from the tools of standards that help protect our mothers and babies? How could you do this? You tell me what consumer protection is paramount. Your actions show us that you care less about protecting our families. Our death and our negligence are interlinked. The families of before who came today in public have children died at Los Angeles hospitals from horrible, painful deaths. The hospital where our children from Bakersfield and babies are transferred to. The negligence that extends from Los Angeles to Bakersfield. We are doing our job to advocate for safe care. Now you need to do your job. Please vote no on the legislative proposal. Save mothers and babies from save the standards, uniform standards. Last time I came to this, I brought my daughter's
7
urn.
seconds remaining.
And in that urn were her, Demi, and Malachi together. We've brought urns, we've brought pictures, we have cried. When are you going to listen? And when are you guys going to do something to actually make a difference and protect us? We're crying out for help. Please, somebody on that board. Nobody protected my daughter. Nobody protected my grandson. I will forever hold this board accountable for that. And at my Thanksgiving dinner, I'll be just like these families, mourning. I have an urn sitting on the table, and they have just memories. I don't know what it takes. Do we need to bring the bodies? I don't understand it. Please listen to these families. And I've been advocating now almost 5 years. Thank you very much. I'm begging you.
Thank you for your public comment. Next here is Chris Bundy. Chris, you should be receiving that prompt.
Good morning, members of the board. Chris Bundy. I'm the Executive Medical Director of the Washington Physicians Health Program. I'm also the Chief Medical Officer of the Federation of State Physician Health Programs, representing 47 state voting physician health program members and international members as well, speaking in strong support of the motion before you today. A model physician health and wellness program will not create a trade-off between helping doctors and keeping patients safe. The argument that it does is simply a false dichotomy. In fact, the Physician Health and Wellness Program will extend the board's ability to protect the public. This is not about helping doctors avoid consequences. This is not a referendum on medical negligence. PHPs are not a pathway to escape accountability when negligence has occurred. The uniform standards, while well-intentioned, were ill-conceived, the result of a flawed legislative process that did not adequately weigh the voices of experts in the field. The proposed program will ensure accountability inside of a confidential process that will not compromise safe care. It recognizes the unparalleled outcomes and effectiveness of physician health programs. Virtually all patient safety science recognizes the primacy of early detection and mitigation of risk before harm occurs. In choosing this path, the MBC takes the approach that is supported by data and science. In the absence of a confidential program to support physicians, there is unmitigated, unaccountable risk in the system right now. There are doctors that are not getting help right now in a culture of silence that perpetuates risk to patients. This fact has been recognized by medical regulators and state medical associations in 47 other states. That is why this is the accepted standard across the nation, a nation that cares as much about its patients as Californians. Thank you for the opportunity to speak today with you on this important matter. I urge you to accept the motions in front of you. Thank you.
Thank you for your public comment. Next up here, we have John Rosenberg. John, you should be receiving that prompt.
Hello, can you hear me?
We can. Please go ahead.
Okay, thank you. Good morning, members of the board. I want to start by saying I'm touched by the comments of many who have described losses they've suffered, and my heart goes out to them. My name is John Rosenberg. I'm a psychiatrist specializing in comprehensive evaluations of physicians with impairing or potentially impairing conditions. I'm a past chief of psychiatry and chief of staff at Altabates Medical Center in Berkeley. I speak today in my role as the board chair for California Public Protection and Physician Health, known as C3PH. C3PH is a non-for-profit organization dedicated to patient safety by informing and supporting medical staffs and medical groups as they carry out their challenging responsibility for patient safety with their roles in identifying, referring, and monitoring physicians who have potentially impairing conditions. We are very encouraged by the board's efforts to establish an effective physician health and wellness program for California that would be in line with the best practices of similar programs in 47 states. I can tell you from my work that such a program is needed and desired by California hospitals and all of those who have peer review responsibilities in our healthcare system. The absence of such a program since 2008 has not served the interests of public safety. We applaud the progress the medical board has made in moving towards this proposed legislation. C3PH has convened a work group consisting of 20 individuals who are statewide experts in physician well-being to review legislative language and plans for the new physician health and well-being programs development. In reviewing the legislative language, members of this group have expressed concerns about several of the elements in the proposed legislative language, and we will submit other comments in the future outlining them. For example, C3PH maintains that sufficient, ongoing, and stable funding is necessary if the program is going to succeed, and we want to find the appropriate way to have the sources of funding identified in statute. C3PH is also concerned about confidentiality provisions of the new program, as this must be designed in a manner that will not discourage physician participation.
30
We
seconds.
strongly support your positive vote on the proposal today, and C3PH stands ready to work with you as you continue work on the specifics in this proposed legislation, and we hope you will call on us as you move forward with the development of this much-needed program. Thank you for your time.
Thank you for your public comment. Excuse me. Next here, we have Black Patients Matter.
Yes, hello. Thank you for the opportunity to address the board. So we at Black Patients Matter have been around for quite a while. And we have learned a lot on planet Earth. We learned that everyone will die someday. We are saddened to share with you all that our brother, our sister, our mother, our father will all die. 1 out of 1 people will die someday. I will tell you that when we die, it will not be joyous. It will not be wonderful unless you have Jesus like we do. That's what we believe. This is not a perfect world. If you want perfection, you can wait on AI and a Tesla robot. In the meanwhile, we do our best on planet Earth. We commend the medical board for taking this step. We have had excellent, outstanding care by physicians who have been depressed, who have had a previous history of substance use, for the young lady who was an alcoholic and is now a counselor. You are proof that physicians are not perfect, providers are not perfect, but can be rehabilitated. And so, knowing that we live in an imperfect world, we thank the medical board for taking this step in recognizing that nobody is perfect. If you feed your children junk food, you are not perfect as a mother or as a father. We no longer work with Consumer Watchdog because they used us. They used us to read a script that we didn't believe in, stand up there, and never returned our call after we talked.
30 seconds remaining.
We no longer work with Marianne Hollingsworth because she disrespected us as Black Patients Matter, ignored us when we went to eat together. So, medical board, we ask that you use with discerning ears and wisdom the testimony, only the testimony of those who say that they were harmed by a impaired doctor.
Please conclude.
Let me tell you, everyone, all of us earthlings, you will die. You will all suffer sadness. You will all suffer harm.
Thank you for your public comment. Last year in the queue, we have Eric Andrist. Just while we wait on Eric, anyone who is not in queue believes they might be in queue and hasn't made a public comment yet, you can use the hand raising feature or just type you'd like to make a public comment in the Q&A box, and we'll make sure you get called upon. Thank you, Eric.
Can you hear me?
Your line's open.
Okay. To the Federation doctor, why aren't doctors getting help? There's plenty of private rehabs they can attend like the rest of us, confidentially. Hi, Eric Andrist here. I agree with the other caller in that you don't seem to be learning who you should be protecting. The overall arrogance of this board demonstrates that you all think you can just do whatever you want despite the cries and pain of the public that comes before you. What other states are doing and what California is not doing is totally irrelevant. That's what kids do on the playground. They say things like, well, everybody else was doing it. Remember what teachers said to them when they said that? Christina, would you jump off of a bridge if everyone else did? Saying we don't have a health and wellness program because other states do is just childish and irrelevant. What do we need in California regardless of what other states do? Not just follow the crowd. We're supposed to be smarter and better here. Doctors are taught to take care of people's health. If they can't understand their own addictions and take care of themselves or have their families take care of them like the rest of us do, should we really be trusting them to practice in the first place? If doctors want to hide the fact that they're in rehab, they can just sign up and pay for a private addiction clinic. Why would they need a state-mandated program to do that? Do you all really want to go to a doctor and not know if they are addicted to drugs and/or alcohol? Or do you rely on being able to see the secret information that's gathered for yourselves and your friends and families? When a movie star or politician has an addiction and goes into rehab, it's all over social media and the news. Some of you non-doctors on the board wouldn't necessarily have the luxury of a confidential state-mandated program. This program is discriminatory and continues to handhold and pet doctors at the demands of the California Medical Association, whose membership is only about 40% of all doctors in California. Why isn't the multi-million-dollar rich CMA, who wants its fingers in everything, heading up and funding such a program since they want control over doctors and patients' lives? Let them put this together and run it privately if doctors need anonymity during their addictions. That leaves the medical board totally out of the picture and not putting yourselves in the position of having to hide yet more information from the public, even though Christina seems to think that's appropriate. This is just another PR thing that you want to try and make yourselves look like you're doing your jobs. If you cared half as much about patients as the amount of effort you're putting into yet another program that strokes doctors, we'd be in a lot better shape here in California in regard to patient harm. Stop listening to the CMA and start listening to the people of this state. I could see if doctors had no access to programs at all, but they do. So a yes vote on this will be only to impress the CMA and not the victims of bad doctors who are spending so much time coming before you. And lastly, I wish you'd put the camera on the whole board while we speak so we have the same access to see your reactions as those there in person do. Seeing the back of the projector isn't helpful, although TJ and Michelle, you look stunning behind it. Thank you.
Thank you for your public comment. This time I don't see any additional requests.
I'm sorry, I was asking a question about the camera, but what, are we all done with public comment on WebEx?
Yes, no additional requests.
Okay, thanks,
The,
Don. And thank you.
Trying to pick up the timer there, so I was trying to get that on there.
I see. Thank you. Thank you to all the commenters on WebEx. I'll bring it back to the room. Are there any additional commenters here in the hearing room? Okay, seeing none, we'll bring it back to the board. I think perhaps we start with any questions that board members have for our staff. Mr. Watkins.
One question. In the section that offers access to the new entrants into this program, there's what gives them access is, or disqualifies them if there's harm and sexual misconduct, right?
Yeah, those are exclusions in the proposal.
Those are the exclusions. And, you know, in my experience, harm is defined in the medical, in the business and professions code, right, Kerry? Harm. Patient harm is defined in there. And I recall that pretty much eliminates a lot of what would be considered harm, because that was hard fought by Jerry Hill. That patient harm definition. And so it will pretty much open the door wide open. It will open the door to all doctors that harm as defined by that definition in the business and professions code will exclude them, and sexual misconduct. You see, so that I just want to verify that.
I know Ms. Webb is looking. It's not coming to mind, Mr. Watkins. What you're referring to is that definition of harm.
Patient harm is actually defined because there was legislation passed for when patient harm is part of it, because it influences discipline, and it was brought on by Jerry Hill. And what he started with and what it finished with was very, I mean, they pretty much reduced that to very little. So I just wanted to make sure if that is the definition that we will go by as to the entry of these doctors into this program.
So we'll give Ms. Webb just a couple minutes to look into that. Are there other comments while she's doing that? Okay, so we'll go to Dr. Thorpe at the end and then Dr. Mahmood.
Sorry, just a couple of questions. One of them is, can you there was a question about why the mandate for a 501c3 corporation versus a for-profit company being another option? That's one question.
I don't know if Mr. Varghese has some comments he can add on the value of a 501c3 versus other forms.
Dr. Thorpe, this is from my past experience outside the state, but as a nonprofit corporation running this program will open up channels for more pathways for funding to come into the program. That's one aspect of it. Now, again, that is what is being witnessed in other states because the previous program failed lack of funding. So we cannot solely depend on the physician community or depending on the state dollars to run this program. Apart from funding, if the fear that if it's a for-profit organization, their motive is profit. So if the participation dwindle, if there's not enough participant and they cannot support their return on investment, they will fold their door and leave. So that's two major factors.
Madam President, one more question.
Sure, please.
And just to be clear, the uniform standards are still in effect during any physician who is being disciplined by the board for substance abuse or substance abuse related issues. Uniform standards are still part of the disciplinary process. Is that correct or not?
Correct. It's in this voluntary. It's the voluntary participants where there would be discretion
and confidential program that without patient harm or without sexual misconduct, that group is exempted from the uniform standards.
The program and the board would not be required to impose the uniform standards on the voluntary participants.
They could impose them.
We could.
Yeah.
The board could decide the program, like Dr. Bundy or others that are running the programs in other states, they could decide as well. So it's a permissive matter.
Thank you.
Ms. Webb?
Yes, I just
so much.
Sorry, Dr. Moon, let me have Ms. Webb follow up on Mr. Watkins' question first, and we'll come back to you.
Mr. Watkins, I believe you're talking about Business and Professions Code Section 222.8.1, and I had to refresh my memory because I didn't believe that harm is defined in that section. And so, I'm sorry? Right. There would have to be a finding by an expert that patient harm occurred for that section to apply. Now, if there's particular concern about the language in this proposal, the proposal can include a definition of what is meant by patient harm. That would exclude, and the point of that section is that they wouldn't be diverted from enforcement action into the program. They may still benefit from being evaluated and monitored and tested and getting into treatment, but the board would proceed with its enforcement action. And remember, part of this is a program can act much more quickly than a board can in getting conditions imposed.
Thanks. Any follow up there, Mr. Watkins?
Yeah, I'll have some ideas about what that would look like, because in the practical sense of how that looks like, and well, maybe we can clarify that right now, that if what we find all the time right now is a doctor is, caught on some freeway crashing somewhere, runs with a blood alcohol level of 0.2 or something, and nothing else is heard, just the barriers, right? Get a conviction, and up to now, when we look at the uniform standards as a cure, but the uniform standards, albeit a guideline, there's many ways to circumvent that. And unfortunately, the doctor community has found out how the board operates to circumvent that, right? But the problem is, in that case, conviction, no harm, just hit the barrier. That person will then be eligible to enter this program and therefore face no board consequence as per this situation, right? I'm
Yeah,
understanding.
I foresee that would
Yes.
be someone who would be diverted into the program and that the board would not take enforcement action if they agree to go into the program and are compliant.
So I'm going to add another element just for clarification, because I think it's more easily understood when we use practical examples. So, right, same situation, same everything. But in this case, you know, this doctor's actions harmed or killed somebody else. Will that then circumvent the issue? Will they then be allowed that same level of protection as the person that just crashed into a barrier under like just harm? Because no real harm has been occurred, but there's nobody that would establish if such harm meets a definition. Do you see what I'm saying? And in that case, if they are allowed into the program, then it gets dicey. And I think that's what the public is. The public is very concerned at this moment as to who is allowed in the program. I am also concerned. I see this thing in two ways. I see that we have this core group of doctors, a very small percentage, according to Dr. Bundy, right, that they have some real issues. The board will probably be involved in some way in their space, but the majority are on a scale from, you know, just starting with stress and building up to their advancement through not getting help. And that is the majority of it. And the physician health program that we propose is to help that majority, catch it early and help people. No problem. That's why I agree with this in conceptually. But the 5%, that's why everybody's here. Everybody's here because they are concerned, like, what are we doing about the 5% that should face a level of accountability that now hides under the banner of the people that are really just needing, they haven't done anything, so to speak. They just need help. And I think those are the two issues that I've identified up to now. And anybody can correct me, because I'm really committed to this issue. This is close to me because I deal in the space, and wanting to find the doctor's concerns, but also the public's concerns. Thank you.
Thanks, Mr. Watkins. Dr. Mahmood?
Yeah. Thank you so much. Actually, TJ took my concern. That's what exactly my concern was. And also generally other situations, somebody has been in substance abuse and has done things, he enrolled in the program and things come up later on, okay, he had these encounters which were already before enrolling in the program, what will happen to those encounters? And the complaint hasn't gone to the board yet, or complaint hasn't gone to the really process yet. Those are the things will be very gray line and will be concerned. So that was my major question. I think you already brought it up. The second one is, I'm not clear about, we have any idea about the funding yet or not? It's not really giving us the idea where the whole funding is going to come. Is the whole physician community going to bear the thing and increase in license, or the physician who will be volunteering will bear the most cost, or some other? I am not really getting much about the funding yet.
It is largely an open question still, Doctor. What we know from at least some of the other states, that physician licensing fees are can be the majority of the funding stream in other states that have some of these successful programs. As I've heard from the other members of the board, have talked about, including insurers and, whether it's on the health insurance side or on the liability side or some of the major health systems, all of the individuals, all the different organizations that are paying costs right now for treatment, whether on the front end to treat them hopefully before harm occurs or on the back end in liability issues, trying to figure out how to tap into those various different organizations that will see a reduction in their costs, hopefully as this program ramps up. What we felt was the first step was to have a policy that this board felt comfortable and confident in. And then with that in place, then I think that, and if legislation gets introduced, because there's nothing quite like legislation getting introduced that really will bring people out from to the table to look at this even more thoroughly. I'm hopeful then the funding ideas will materialize. Now, I don't think, strictly speaking, I don't think we need to identify that at this point for the board to move forward if the board wishes to. I don't know necessarily that the legislature has to identify funding before even enacting a bill like this. The legislature has a lot of tools and options at their resources to put policy into place without funding for something being identified and deciding to deal with that at a later time. So there's a range of options, Doctor. I hope that's helpful.
Just to follow up, I could understand that there is not a plan for funding, but do you have a budget in mind that what kind of funding you'll be looking? Because any program, it cannot be applicable if you don't have the tools to run that program. And a budget is the most important thing. And if you don't have a budget, who will be funding and how they will be looking at? I personally think the legislation will also ask this question, okay, where the funding is going to come? This will be their first question because that's everybody's concern. So at least having a budget in mind that, okay, first 3 years, how it's going to run, or at least some rough estimate about that, looking at our previous history and kind of stuff. That'd be helpful.
Yeah, so I think the only answer that I have, and maybe I don't know if some of the other staff have thoughts to share as well. The only information that I have thus far that's responsive to that, Doctor, is the prior comments that we received at the May board meeting about you could have between 1% and 3% of the physician population, the licensee population, using services, at any given, point in time. We do have some funding projections with respect to the substance abuse side of things from our regulation package that we were considering. And those were substantial. I think tens of thousands of dollars spread out over a 5-year period for individuals just for substance abuse. The challenge with giving you a very detailed answer at this point, Doctor, is that, well, one, that's going to be settled through a contract. So as one of the things on the slide indicated, that's a very important milestone that, we're some time away from. And then that will largely, then the other budgetary consideration is going to revolve around how many people are actually getting enrolled and what's the level of service. On one end, you have education, you have, counseling. And then on the other end, I suppose you could have, inpatient treatment for a very severe disease. So it's an important question, Doctor. It's something that, we understand very well that this cannot be fulfilled without a robust amount of money. But that's all that I can share at this time.
Nothing further on that. And that Aaron covered it all. Thanks.
We'll go to Ms. Remke and then come back to Ms. Torres. Ms. Remke.
Okay, thank you. I just want to follow up on what Mr. Watkins was talking about because I have a similar concern. And from my reading of this, it really goes down to the definition of a participant who has been made aware by the board and the board sending them into the program as a condition of probation. I think if I'm understanding it.
Repeat your question, please.
Just the participant versus the voluntary participant, because a participant is someone, it's going to be publicly known because it's a condition of probation.
That is a class of participants, yes, who have a probationary order from the board and then are sent.
So it's, again, to the concern about public protection.
Yeah.
That's out there.
Yeah.
Right? This person has this violation, and they're now getting treatment as a condition of probation.
The probationary term order is publicly available. Yeah.
Right.
It's just that a participant can be either ordered as part of their probation or can be a voluntary participant.
Well, then when you look to the voluntary participant, and again, somebody who maybe has allegations pending against them, and they're sent in lieu of discipline to participate in this program, right? I guess that's where the concern, or at least the concern for me in public protection, comes up, because now what do we know, or what's out there about the pending allegations and or them seeking treatment?
That wouldn't be public. So take, for example, a DUI where involves we'll just take, there was no collision, there was no harm to another person, this person was pulled over, they have a DUI, and the board becomes aware of that. Right now, the only tool is to pursue disciplinary action.
Right.
If this program existed, the board could say, we're going to pause this disciplinary action and we're going to send you, if you are agreeable to the physician health and wellness program. They're going to evaluate you and determine if you have a substance use problem or if this was an aberrant event. And if you have a substance abuse problem, then you are going to be required to get treatment, maybe do support group meetings. You're going to have to undergo biological fluid testing and regular monitoring for a period of time.
But I'm going to, that case is a little bit different because there is a conviction, and most people are going to know about the conviction, or if there's a way to find out and the public can put it out there, this doctor has, a DUI, beware, right?
May or may not be a conviction at that time.
Right.
The
Okay.
point is,
so what,
they're monitored
if there's no
early.
conviction, and or this came out as a result of a complaint, and it was a low level complaint, or let's say, based on what I'm understanding, no client harm, and no sexual misconduct, right?
Right.
What would be public at that point with that person? Let's say it's record keeping, and we're like, okay, but there's now been notice that you might have a substance abuse or mental health problem, and we can divert you into this program, probably the best case scenario, right? Really low level violation. We don't have to go through the whole process, but you do need help. So
Right. The public would not be notified.
Okay. And maybe it's in here or maybe it's understood, but I don't see it. And again, so in addition to on that voluntary participant track, where there is pending allegations and they're not going to be known to the public, but we've made a determination that they're not related to client harm or sexual misconduct, is there another requirement other than once they get into treatment? And I'm looking at the part once someone's in treatment and there's a violation and it comes back to the board can let them continue in the program if they determine that the person can continue to practice in a reasonably safe, competent, and professional manner.
Yeah.
My question is, long question, is that a requirement to even go into the program without public disclosure? And I would say that seems like a given to me, but I don't see that.
Is that a requirement to go into the program? To
And
be
not
able to
disclose any
practice?
information. Yeah, we're just saying you need help. Go into this program. There's no allegation of client harm and no sexual misconduct, so we're gonna divert your discipline.
Right.
But to me, there's no determination at that point by anyone that they are capable of continuing practice reasonably safe, competent, in a professional manner.
That is part of what the program would be doing in their initial evaluation and intake.
Right.
So
But it doesn't say that. And I guess to me, that's a safeguard. We're not just diverting people from discipline and as the public has raised concerns about why are you protecting these people when they can hurt people? But to me, if that determination's made, I think it puts everyone a little bit at ease. And or if it can't be made, then they should perhaps be placed on suspension until it can be made. Does that make sense?
Yes, and certainly that's something that if you find the language unclear as to that point, can be clarified. But the program can do that much more quickly. The board,
and I think that's one of the selling points. And I definitely, from that last meeting with the professionals running it in other states, I'm convinced that the ability to suspend someone or pull them from practice because they're in the program and they see a slip or a problem is one of the benefits of this.
Yes.
But again, to me, and the concern that, hey, you're protecting and hiding and shielding people. I'm not saying we're doing that, but that's the perception. If there's nothing out there, there are allegations, and we know about those allegations, but they're not going to become public while they're in the diversion aspect.
That's right.
I think we need to have
And
at
they
least a
wouldn't
determination.
They wouldn't
of
become
reasonably
public
safe.
anyway at that point.
Pardon me?
They wouldn't if a DUI.
Well, let's not use the DUI because that's
Okay.
too easy for me.
Yeah, someone's partnered.
If someone makes a complaint, that is not public at that time.
Right,
It
right.
has to go through the investigation.
Oh, I get it
process.
again, but now I'm saying we're
Accusations.
diverting them, and
That's
I
right.
think that's where some of the concern is. They're in a program, there are allegations, those aren't coming out unless something goes wrong. But we should have the comfort level of knowing we are diverting them with the understanding that they are still reasonably safe, competent, and in a professional
At
manner.
that point, the board staff doesn't know. The board is diverting to the program for an evaluation.
Well, then I guess I would say that their acceptance into the evaluation is that's a condition, but that doesn't say it. It says it's a condition to send it back to us and we can decide what to do then. It's not the beginning condition to get into it, that we're doing this in a safe, professional manner, as I read it now. And maybe I'm being more technical, but to me, that's important enough that it should be up front.
Okay. I think we had Dr. Thorpe and then Dr. Yip next.
Actually, I think Dr.
Actually,
Yip was
Mrs.
first.
Torres was next. I'm sorry.
Yes, Dr. Yip may want to respond to that.
Okay.
I'm not going to wrap it at the end, but I try to help with that's the concern we have a staff meeting and discussion about clear. The concept is there. When you look at Dr. Bundy's program, the concept's there. One of the goal of the program is to capture, not like capture the licensee who potentially would cause harm, who potentially go down the path of impairment, but not to the point that would fit the criteria being mandate for probation. And you're absolutely right. We have the same concern. I think somewhere we put those language, but not as clear. When you read like 2340.18, it's about, if they're not in compliance, etc., the director of the program will report to us. Now, we can make it more clear. That's why the advisory committee, how to set criteria, who will need to be reported. It can be a gray zone that they will report by their MR medical record number only, rather than by license name, because they're not mandated for protection, but at least they're under our radar. Okay, I think we need to put more clear who are those licenses that we need to potentially put them into the mandate program. You have a very good point about what if the physician being possible relaxation, but he said, I want to be in the program. Doesn't mean it's our jail-free card. If the DAG and the enforcement committee say, hey, you need to be on the mandate program, they will. It's not like we give you a ticket and that's it. I don't think that's the idea, but I think we can put it more clear. So
Thanks, Dr. Yip. I understand that Dr. Bundy, who is an advisor to the board on this, to the development of this program, is available. And Sean, if you could promote him so he can help us answer Ms. Remke's question as well.
Mr. Bundy's online. Dr. Bundy.
Oh, good morning. Thank you. Can you hear me?
Yes.
Okay. Just at the risk of sounding like I'm shamelessly pandering, this is an excellent discussion, and you've honed in on, I think, a critical component or question. This is about how the program will ultimately collaborate with the board. And there's nothing in the way that a model program should be set up in a state that precludes there from being parallel process. I think that the way, when you read the legislation, you kind of envision this dichotomous process where there's a either or. The individual goes to the diversion program or to the PHP, and then the board is hands off or not. And that's just not my experience when there's concerns about when you have a reason to be regulating that professional independently of their involvement in the PHP, that process can still and should still continue. So we can help. Sometimes that referral to the PHP, either maybe in the investigative phase of the process, that might stay you from moving forward. You stay in communication with the PHP. You ensure that the individual is following the PHP program requirements, and that may or may not determine whether or not you want to continue with an investigation of the complaint or not. That's always within your purview when an individual is known to you. You may, if it turns out that the complaint was related to what you think might be an impairing health condition, you really feel like there was no patient harm, the complaint was about impairment or concern for impairment, and that individual is getting help from the PHP and doing well, and they're enrolled now, and they're going to continue in a monitoring program with the PHP. You're going to be notified if the individual is out of compliance with the PHP. You may decide to close that investigation. On the other hand, there may be circumstances in the complaint that, yes, the individual should and can benefit from participation in the physician health and wellness program, but you also have a duty to discipline. And in that case, we understand that, and that all remains within the purview of your judgment to determine. So just because somebody's in the PHP does not, it may mitigate discipline, it may not. And that's ultimately your call to make. Does that help in terms of what your questions were or thoughts were about this?
Mr. Remke, does any follow-ups on?
I mean, I don't think it directly answers my concerns, and I would like to see, and I guess the question would be, would it be inconsistent with the proposal to have an actual condition that says any voluntary participant who is deferred to the program must be determined to be able to, that same language that's used elsewhere, continue to practice in a reasonably safe, competent, professional manner, or will be placed on suspension until such time that determination can be made. I mean, I think that's the crux of people getting concerned, at least again from my point. And I have seen this in my other world with the attorneys, and we had the diversion program, and it becomes an issue or the concern, you're diverting people and they're still out there and we don't know about their diversion. But if we have to make a determination, or the professionals, we refer them to there for the treatment, but before they're signed on the dotted line to get into it, that determination has been made or they've been placed on suspension. Just to check the box, yes, that's been done. That would be my proposal or suggestion, but again, I don't know if it's inconsistent with what we have here, and I'd be curious if it is.
I would say in my experience, the way this works is that if you have concerns about somebody continuing to practice, one, those concerns would be expressed to us in the process of you sending somebody to our program. We would make our own determination about whether we're going to ask them to voluntarily cease practice. Typically, when we ask people to do that, especially in the context of a board complaint where summary suspension may be forthcoming, if an individual doesn't voluntarily step out of practice, we can facilitate that rapid cessation of practice and medical leave. But in the case rarely where somebody might not be willing to do that, or where we don't feel like it's indicated from the perspective of a issue of impairment, then we would advise accordingly and say it is really up to you to proceed with the suspension in that case. But again, I think it's around collaboration. But usually when the temperature of the water warm with regard to the concerns of the board about an individual's safety to practice, the better part of valor is going to be a recommendation that individual cease until we determine that they are fit to return and provide the board with reassurance that we have deemed them fit.
And I can provide some scenarios if it's helpful of how I understand this would work, but I'll look to your direction when that's appropriate.
Okay. I think it's an important question, and I think it goes to how these, and I think this is what Dr. Bundy was hitting on, how these programs actually work in practice, right? What is the interaction back and forth? When would we be seeking that interim suspension order, right? As a board, what are the criteria under which we would do that, right? And then what are the criteria that the program is using to assess those inbound into the program to understand whether or not they're competent to continue to practice or whether they need to cease practice voluntarily, right? So those are two different things, but there's some continuum there that I think is what we're seeking to understand. So let's keep going with comments here, because I think there's agreement actually, or consensus amongst the board members that that's something important for all of us to understand as this keeps working its way through the process. So I had Ms. Torres, and then I've lost track. I think Dr. Thorpe.
And I think that some of my comments I think have already been addressed. But I mean, I just wanted to emphasize, as Dr. Yip mentioned, you know, especially for folks that have come forward voluntarily under the voluntary umbrella, this is not a get out of jail free card. And I don't mean that in the criminal sense, but I mean that in that, you know, if an individual comes forward because they need treatment and they themselves believe that, you know, they need help, like so many in the medical profession do, and just have no recourse, you know, that's what this program is meant to establish and to assist with. But certainly if things continue to change, or if that person, you know, is not cooperating with the voluntary program, I mean, there's a easy pivot back and forth to the board. I mean, and that is written in the language that the board, it's permissive language, that the board has the authority to take disciplinary action should the situation change. So I think that that's, I just, again, a point that I want to emphasize, that people that come forward voluntarily, it's still a program. There are still conditions. You still have to maintain good conditions and cooperation in the program, and not, and if that were to change, there's a lot of options available.
Just to quickly add on to Ms. Torres, that a lot of the detail and the flow, the back and forth would be detailed in the contract in the various procedures.
So we'll go to Dr. Thorpe, and then Mr. Watkins, I see your hand.
Thank you, Madam Chair. So another question along this same line that Ms. Remke and Mr. Watkins were pursuing. Mr. Bundy, could you speak to, so one avenue that I think is not just overtly being recognized. We're talking about, you know, somebody who is coming under discipline from the board, who we send to the program, and somebody who individually reports voluntarily. But there's a whole nother set of reporters in that hospital medical staffs, medical groups, people who are partners of physicians are currently reluctant to report because of the, you know, they don't think the guy's bad enough to take him out of practice, but they do think he needs help, and there's no place for him to go. And I'm not trying to, you know, that's not like a sympathy thing. It's just the reality. Those people are not being reported currently, and there's a real need for that. So my question to Mr. Bundy is twofold. Number one, well, I guess the question is, if people are reported for mental health issues or for substance abuse issues, in your experience, do you validate their ability to continue clinical practice as part of your entry into your diversion program as part of the, whatever it is, mental health, substance abuse, whatever it is, wherever they get directed for care, is part of that assessment that is the initial entry into the program. Is clinical capability, or both emotionally and technically and cognitively, is that part of the assessment program into your program?
Yes, thank you for the question. And just so people are aware, I am a physician. I'm a psychiatrist by training, and I'm a geriatric psychiatrist and addiction medicine specialist. Our process, and I think all PHP processes, that issue, is this individual safe to continue practicing pending further evaluation, is probably one of the most important questions for somebody being referred, that we're seeking to answer when that referral is coming in. Certainly, we're going to get referrals from time to time. It's actually pretty unusual to get a referral of somebody who's actually, frankly, say, intoxicated in the workplace. But somebody who's intoxicated in a workplace, that's an ominous sign for impairment. We're going to be having a conversation with that employer, that credentialing entity, whoever's making the call, saying we really would recommend that this individual cease practice immediately pending further evaluation. And as a voluntary program, we can't make anybody stop practicing. So we really have to have the partnership of that employer or credentialing entity is going to be the leverage to have that person stop practicing. And that's usually fairly easy in a situation like that. But you can imagine we also have situations where there's a much lower level of concern for impairment. But again, to speak to the issue of utilization of the program, you've got your chief medical officer who's having practice-related performance concerns. No patient harm has occurred, but there's concerns about safety. There's concerns about, is this individual, maybe they're delinquent on their charting. Maybe they've had some eyebrow-raising events. Maybe there's some irritability, interprofessional problems in the workplace. And they're thinking about moving down a path of progressive remediation for the behaviors, and they want to ensure that there's no health condition that might be generating some of these problems. So they're referring the individual to us with really a lot of uncertainty about what's going on, or even if there's a health condition behind it. So in that case, they may not be stopped from working. There may be no cause to stop them from working at that point. However, they come in, and what we're going to be trying to do as part of our intake and initial assessment process is determine, is there more to the story? And if we learn that there's more to the story, that makes us concerned about this individual's ability to continue practicing, then we're going to recommend that cease practice, that back to the employer or the credentialing entity or whoever has the ability to stop that individual from practicing. And if that recommendation is not followed, that is a program requirement at that point and can trigger a mandated reporting obligation of the board, which can also then inspire and motivate others to go ahead and take that voluntary cease practice course of action. So you can imagine that there's there's a number of cases in which that's a very important judgment call that we are trying to make right upon entry into the program. And that's an ongoing assessment. Sometimes we may decide that an individual is safe to continue practicing pending further evaluation or enrollment in a health monitoring or support agreement, but that can change over time as well. So the issue of fitness is always on our mind, but also but prescient coming through the door.
That answer your question, Dr. Thorne? Thank you. Mr. Watkins?
Yeah, I love hearing about this. And, as I'm listening to everybody, it's becoming more clear the core issues stay the core issues, because the program promises right now no get out of jail card for participants in this program. Here's where it will be in conflict with the public and, our personal experiences for various reasons. And one of those things are right now, and the program, implementing this program requires a high level of trust between the board and the PHP, a high level of trust, right? That says that they will be sensitive to each other's recommendations and act upon it. let's move to reality. This is what most people have experienced, including us on the panel. Right now, if in the real world, in a real like uniform standard case, we can come across a doctor that's substance abusing, that has violated probation many times, 2, 3 times. They've been given citations, he's been given all of these things, and the board hasn't acted to actually revoke him. We have come up with more reasons, even that is proven that this respondent is not rehabilitating or can be rehabilitated and should actually be exited from the program and join some program like this or a professional program. My question here, and this is to Dr. Bundy, if you have a situation like we have in California, in your experience, where the patient advocates and the people's experience of the board is at that low trust level, right? How do we build, and I'm battling with this, how do we build the trust back? How do we as the members build the trust back with that community over there? And we bring in the doctors and say, how do we now create this environment that we can, actually say, hey, we stand behind this program. We want our doctors better, but we also want accountability for those folks that did not meet the standard, because up to now, people could walk through the standards. And I'm sorry to say that, the standards, there's too many loopholes in it. There's so many, we see it on the board. Right. Last year I had a case here where the attorney for the respondent gave a packet with 40 cases to show how much we've deviated from the uniform standards. And it was startling to me that now our actions are acting against us. Why? I say in concept I support the program, but I want to find the best balance between the public, protecting the public, and keeping doctors healthy. I'm struggling with that. I'm looking to Dr. Bundy to help me address the trust issues that we have, some of the transparency issues, which is more related to, that you want the privacy of the doctor. So we have trust and we have transparency. We want the privacy of the doctor to be respected, but we also want that trigger that says, hey, the public needs to know now. And I think California is kind of unique, or maybe that's just me, in the kind of issues we face that needs fine-tuning. So that's my question to Dr. Bundy. How do we overcome the trust and transparency? How do we build it up in your experience?
So a couple of comments from me, and then Dr. Bundy will go to you, because I think this is foundationally what's underlying everything. And it's why in my opening remarks about this agenda item, that it was important for us to acknowledge clearly that we failed with the previous program. What they're telling us, what we were told, right? 5 times. And none of the same members are here, but what the board was told 5 times was that your program isn't working. So now we've been in a situation where we've chosen for 15 years to have nothing, right? Almost scared of having a program that meets best practices because we failed in our effort prior. And that's real. And by the way, all of the awful situations, and I'm profoundly sad for all of you, we're failing the public when harm continues to happen in this system. But part of this is about us having the courage to evaluate the best practices, look at the evidence, look at what's working nationwide, and say, we are going to try this again. Notwithstanding that we failed previously, notwithstanding that it didn't work for a variety of different reasons, we are going to do something rather than continuing to do nothing. And I really do worry about the fact that there are impaired physicians in the system now that are not coming forward themselves. To Dr. Thorpe's point, they won't be reported to or referred to a program by their colleagues who are beginning to see the signs that there could be impairment, even even if it hasn't risen to a level where there's some competency to practice. I really think this is about ensuring patient safety in the most effective way possible, but we're going to have to build a program and then we're going to have to prove it out, right? And that is going to take us some time to do. I know that there will be skeptics. There are skeptics, of course, here in the room that we've heard from, but I don't believe that means we should do nothing, right? I think we should try to build the most effective program possible based on, again, data, best practices, the experts our staff have been talking to across the country, and prove to the advocates that we get it right this time. Now that there's a lot of trust, and you can't build that trust up right away.
And that's my point. You see, so if I were to argue that point right now on behalf of the patient advocates, right, we're talking about, partially or fully repealing the uniform standards. That sends shivers on everybody's spine right now, because they just have one memory of us, one memory, how it used to be. And up to now, the system has not served them. That's legitimate. That is a core fear. You can't overcome the fear by pushing more. So we had a stakeholders meeting a few weeks ago. I joined that meeting and didn't speak. And then I saw a lot of physicians jump on that call, right? And not a lot of the patient advocates jumped on the call. So I went to the previous meeting where the patient advocates jumped on the call, had many suggestions, written comments and everything. And almost all of it was never accepted as part of the game, as part of the proposal, because we were kind of not dead set. We were committed to find best practices, right? And I must say, best practices is great, but it's also specific to this environment. Best practices is the structure, and then fine tuning what those best practices look like within this community. It's almost like the standard of care now. And what I'm saying is, when they did not get hurt, we did not instill more trust. And I'm wondering, and I'm going to wonder this out loud, is whether we should re-engage the patient advocates and see, is there a way? Is there a way that is an in-between step? And I know Dr. Bunley is going to say no, because this is best practices, right? But every time I have been in a situation where I'm forcing something on people, I get more resistance. You should know that, which is hilarious for me to say, to me anyway. But when you push it on people, they just become way more defensive. They shut down. Nothing happens. And I'm almost asking the patient advocates to come out of hiding, right? And we dismiss this is bad, blah, 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 but come to another meeting, whatever it takes, to have that conversation. Because I really, really believe we need the trust of the public to make this happen. Otherwise, at every level during the process, we're going to catch headwinds for every failure. And it may not be a failure, it may be a glitch in the system, but we will feel the heat here. So that's my concern. I am just really concerned about, building the medical board in something that we can trust. Good faith. I'm obviously eternally optimistic and positive, forward looking, but you have to be if you want to do something different.
Dr. Bundy, any comments about the trust building and the importance of that in this process?
I would support it. I think these fora are not necessarily conducive to the kind of conversation and dialogue that allows people to really come together. So figuring out sort of how to do that, who to engage with. I think you want to engage with people who are able to have, a meaningful dialogue about what the concerns are, and look at, how the different ways are of operationalizing that. You've said yourself that, attorneys can drive trucks through the holes in the uniform standards as they exist. yet they're being held up as, you know, some type of shield that's protecting patients. I would argue that it's sadly ironic that they're doing just the opposite, that they impose, you know, really extraordinary demands on any program that would propose to monitor physicians and do it in a way that will cause people to avoid utilizing any program that's subject to them, while also not providing the protection that people think that they're providing. So I think it's sort of being able to have that discussion, but also talk about accountability and transparency. What will be the accountability and transparency measures that you will expect of the Physician Health and Wellness Program in California? I mean, I provide annual reports to our Department of Health. I provide annual reports to our state medical association. We talk. It's built into the deliverables of a contract of what are meaningful variables to be measuring that would provide that trust and that reassurance over time without making it so onerous. I mean, you could measure a million things and make it impossible to actually administer the program in an efficient and resource mindful way. So it's like, what are going to be the important things that you want to know about how the program performs over time, particularly with issues around safety. So we heard a lot of testimony, you know, tragic, heartbreaking testimony from patients and their relatives who have been harmed in medical negligence. Yet I was searching for the data in those stories that happened at the hands of an impaired professional, and I wasn't hearing it. And so while I see the connection and the worry, I think as these programs go along, asking questions about, are these professionals in these programs harming patients? Are these professionals in these programs, are they being hidden or protected in some way while practicing negligently? And how do you measure that? And I think there are ways to measure that. That gets into a little bit of how the sausage is made. But I do think it's that ongoing, it's you know, involvement in the engagement stage. It's ongoing involvement and a commitment to having an ongoing conversation around these issues over time that can build that trust. But I think it's also understanding, as you kind of alluded to, we have to self-regulate in healthcare as well. So we need to not be deaf to our critics. We need to not be deaf to consumer advocates and others. But we also need to recognize that self-regulation recognizes the value of expertise in how we regulate and the importance of that as well. There are times when rational discourse cannot be had. And it's also recognizing that we're not always going to be able to bring everyone along. There are going to be people who will never change their mind, no matter how much effort we put into building their trust. And that's okay. That's the way of the world. So if our goal is to have everybody be rainbows and unicorns about this, that's not an achievable goal. Because there simply won't be. I've been doing this too long to know that that's just not going to be the case. But the question is can we bring enough people along that see the value in this work and the safety that it provides to move things forward?
Thanks, Dr. Bundy. Dr. Mahmood?
Yeah, I have one more little concern is some physician presenting him voluntarily, that's a different story. When another physician or other staff member is reporting on that person, that problem is most of the time, not all the time, most of the time is quite severe. And that is not really volunteer presentation. That is somebody's reporting and he's been trying to avoid, he's been trying to do everything to hide that. And taking that is a volunteer thing, I think that should be taken a little bit more seriously and have more rigorous inclusion in the criteria. But I would think that is completely different thing when somebody else is reporting.
In that the language should be changed to what degree, doctor?
I would think the people who are being reported by somebody else, that should not be taken as a volunteer, because that is being reported by somebody else. Then he has no choice because he's being compelled either go to the disciplinary action or adopt this program so that he can avoid that. So we should bring this thing to physician community or whatever, that, okay, this program is purely a volunteer based, not like when somebody has somebody else is reporting, most of the time, if not 100% time, at least 75% time, problem is pretty big. The other people are noticing something is going on, and he is not coming forward. And now he will only come forward that people are noticing, and he has no choice either to go through a process where he's going to be disciplined, or go through a process where he can avoid the discipline and get the treatment. And everybody's going to basically go through this thing. So there should be some, I think, more thought process than that when somebody else is reporting.
And Dr. Mood, I think you're getting to this sort of continuum question, right? That Ms. Remke was, I mean, highlighting with her earlier comments, right? Because there's everything from, I mean, if the hospital system, for example, has disciplined the physician and they're still recommending it, that probably was required to be reported to us in some fashion, right? But I think what we're trying to capture here with this expanded program is those, you know, I mean, things I see from time to time in my law firm, right? Well, something seems off with that person. That doesn't seem like normal behavior. Hey, they didn't show up for work twice, right? And they keep calling out sick. These very subtle signs that something may be awry that right now we can't capture in our system in any meaningful way, because of the risk of discipline, right? Because of the risk of actually getting that wrong. Maybe they really were out sick versus having some type of impairment program. So I think it's important as this process continues that we think about that continuum. And I think the way Ms. Remke, described it from her point of view about, are they competent to practice medicine? I think that's maybe a good way of framing and working and collaborating again as this legislation continues through the process. I also, again, just wanted to amplify what Mr. Bone said at the end of his presentation, which is, I mean, essentially, we're still very early on in this process, right? This is about, do we want to make a proposal to an author that would then, make a proposal to the legislature. So there is a lot of collaboration, a lot of stakeholder engagement that will occur throughout that process. And there's still a lot of unknowns about what that process will look like or how it will transpire. Mr. Bone, and then Mr. Watkins.
Yeah, and yes to all that. And then again, the contract.
Right.
The contract is going to be a critical component that will, I would expect, flesh out many of the types of the flow of information and the back and forth and how do we interact with the PHWP. That is going to be laid out to a substantial degree in the contract, which I recognize is that's a long time. It's a ways in the future that we're placing trust in. It would require the board's trust in what that process will look like down the road.
Right. Okay, Mr. Watkins, and then I'll look for other comments. Yeah.
Yeah, I'm going to rely on some of my expertise now, because there's something interesting that happens in a collaborative effort, which is synergistic, right? And right now, I feel, and I may be feeling this wrong, there's a lot of people sitting on that side that feels alienated from us because of various reasons. And what I want to propose, and this is a reach, and there's nothing more in life than taking a reach goal, right? And the reach goal was, we used to have this meetings where Kim Kirschmeyer, Denise Pines, previous folks here, they used to do these stakeholder meetings in person. But instead of putting a structure, and I know this is a risk for the board always when you open up a meeting, but you set a requirement. The requirement is that if everybody here, we know that you are very specifically opposed to this for various reasons, right? I want to help the process along. I have my concerns, but I'm willing to work with those fears within myself. And here's the risk, is like if we sat down, so we had this meeting this whole morning, if this was a dialogue between us and them, where we actually say, bring the solution to your concern to the table that you want to see. And we will have a conversation about it. That's a laborious process, but it's very participatory. And it's a way of giving everybody in this process, everyone, their voice. their best shot at bringing their solutions. We have ultimately the discretion to accept that proposals or reject that proposal. But we want to be robust in our process, that we have done everything to build the trust, to build the transparency, and to find the best model. We know it's not ideal. Nothing is going to be ideal. We are all having to take a risk. Dr. Bundy is the expert. He has taken the risk, and for him, it's pretty clear-cut what we need to do. For us, it is less so. And for some of us, the fear is there. The fear of losing the uniform standard for me is high. But I'm willing to be open enough to say, hey, let's see if this system can offer the remedies that I may have been asking for. So where do we, we do the meet. So this is what it looks like, perhaps. We do a board meeting, and we take this Friday, and instead of doing the full-on deal, we say we do a stakeholder meeting, and we bring real solutions. We're not going to decry the process. We're going to go solutions only, have a conversation, be open to hearing things that you don't want to hear if it pushes back. But we want to put everybody almost through the fire so that we can find the purest product at the end. That's my proposal, because I just feel like we have built some relationships with the public, and I don't want to just do something and jeopardize that. I really feel that the medical board is on the right track now. And, I just want to say that.
Thanks,
So
Mr. Watkins. And I will say that I just want to acknowledge how much work staff did put into over the past 6 or 9 months in reaching out directly to a wide variety of stakeholders, right? Many of whom are in the room today. I agree with you. I think there's more opportunity to do that. I would support us having some sort of meeting where we can continue the conversation. I don't think that's something we should. I agree with you. I'll say it that way. Ms. Mitchell, I saw your hand go up.
I was just going to ask for some clarity on what the process was, because I'm slightly confused. There was a meeting with Mr. Watkins and the advocates talking about this proposal, and there was a list of suggestions, and those were ignored. Is that what I heard you say?
No, I think he was referring to actually the task force. I'm forgetting what we called that.
Interested parties meeting.
Interested parties meeting. So that was a formal meeting that Dr. Yip and Ms. Torres hosted, several weeks back.
October 24.
Yeah, to receive input. So, but I think that's what you're referring to. Yeah, and the previous meeting as well.
Your microphone.
What happened the first time, we had a lot of public participation. They made recommendations, and those recommendations weren't included into this program, because if you go through it in the last one, right, it was just like lined out, because we didn't fit with, best practices. So we sent that back last time we were here. And then the task force was commissioned, and the task force had another meeting. But in that meeting, the participation rate from the public was way low, almost like despondent. You can hear it in their voices, like despondent, wow, we're not being listened to. These are the cues that doesn't get said, and it just comes across with a lot of energy, like we feel justified. However, right, people want to be heard when they don't feel like they've been heard. So that was the process. Now, I am suggesting a fresh new opportunity, not on the phone, but in person at the board meeting, where we close out the board meeting early and we have a stakeholder meeting and we actually have this discussion. But the requirement is that you have to show up with the solution for your criticism. What would work for you in a program that would move forward? And if you say nothing will work for you, that's fine too. Then we will know that you did not have value to add. But we at least have to give something new, do something different if you want to have something be different. It's a life rule. I'm taking the step of doing that because I have been the most opposed to everything that the board has done. And I just feel like it's a responsibility that I have to do something different too. That's what I mean.
Ms. Mitchell?
Okay,
Carla?
well, just to say, I am very supportive of obviously stakeholder input and the process. And so that's where I got slightly confused. So whatever, we move forward with on a stakeholder process and the legislative process, which Mr. Bowen and I know very well, is very stakeholder input heavy, right? There are opportunities for all the bells, et cetera. So I think that that's great. My question is two things. If you want to move forward with a bill, the concept, which will go through iterations, and there's no funding attached to it, then how would that work? I mean, I realize that that's something that the legislature has opportunities, but
Yeah.
technically, say a bill was passed, signed by the governor with no funding attached to it.
Yeah.
What do we do with that, the MBC?
I think in that event, that would be, I hope, Ms. Mitchell, a significant catalyst with the other stakeholders to then determine the funding and identify it, perhaps enact a new statute that would, if it's going to be a fee increase, that's going to, for our licensees, that's going to take a statute. If it's going to be some other funding that's going to be diverted from other existing state funds or from other stakeholders, that likely may require, a statute as well. So there's I suppose, a bit of a chicken and the egg, which comes first. It strikes us that if we don't settle at least on this part with the policy, then the funding will never materialize.
Okay. And in addition, you'd said that a lot of the issues would be worked out in the contract, the details in whatever contract we have with the outside.
A lot of procedures. Yeah.
Correct. What would be our input as board members and then also as advocates in that process of like how that would work out, how that would be worked out?
I think there's options for, for the board and the staff. I mean, many contracts are handled by the staff,
right,
under the direction of the board. I don't know that we're necessarily limited to that or other options are precluded. I don't know if Mr. Barker.
I mean, I'm not suggesting that we get in the weeds, but if many of your responses were those details will be worked out in the contract, and I think that there are some legitimate policy issues, particularly with Commissioner Remke's comments, that there needs to be a strong evaluation. So, so my question is then, before we have a contract, if we get a policy passed and we don't have funding, it would be status quo, correct? I mean, we would be in a status quo, what is happening now, which is really nothing, right?
Yeah, this is all contingent upon a contract being executed.
Okay.
And the contract, I can't imagine how a contract would be executed without a sufficient amount of funding.
Right.
Now, maybe there is some sort of a ramping up phase where, you don't need you don't need all the millions of dollars identified at day one. Maybe there's some sort of a step approach that can be taken.
Right.
Those are some steps down the road.
Okay.
Is that helpful, Ms. Mitchell?
Yeah, that was helpful. In addition, I would just like to say that, many of the consumer advocates that are here, I want to make sure that they go through the process of filing complaints and doing the necessary, because obviously these are horrific stories and tragic and heartbreaking and hard for even us to listen to. I can't imagine what this family's going through, but I want to make sure that the process begins for that outside of this PHWP process, right? Because they're really kind of separate. I think as Mr. Bundy pointed out that, they're separate. So I like the idea of this because I think it is more protective of patients. I think that it will lead to increased reporting. So therefore there will be, more physicians that are part of a program and that get reported instead of just, being hanging out. And then, as I said, I like the language that board member Remke suggested. And then, oh, just some clarity on when we said they get diverted to a program, they are then assessed for whether or not that they can practice. Correct? I mean, that's the language that we're looking at putting in. And then, correct?
Yes, they would be evaluated to determine if they're able to practice in a safe manner.
Right. Okay. And then would we get reporting to the board of, you know, what is the dialogue, I guess, between the PHP and the board after that, right? I mean, do they just go into, obviously they would go into this program and then we would know how many people are in the program, or how would that work?
So in public meetings, there would be regular reports of aggregate data, so de-identified information about, you know, the various data that the board's interested in. How many people are participating? How many people withdrew, terminated, completed the whole program, and so that would be in public meetings. But the PHWP program and the executive director or his designee, and that could be the committee, the advisory committee may be established to help advise the executive director about whether this person needs to be reported to the board to initiate a disciplinary process, or if they have been instructed you cannot practice right now and they're being compliant with that, they're getting treatment, they're being monitored, then it may be appropriate for them to remain unknown to the board by name, because they're being compliant, they're not practicing, they are not putting patients in danger, and they're getting appropriate treatment. If that person is not being compliant, they're not agreeing to not practice, they won't submit to biological fluid testing, then that would be, the board would be notified of that person, and that is someone that would end up in the disciplinary tract, and the board has tools to deal with that.
Right. So they would end up, because Dr. Bundy is the one that said he would, you know, reach out to the hospital or wherever they're practicing if they would then not be allowed to practice. And so then that information would come to us as well if the hospital didn't, if the hospital would agree, assuming, but if the hospital didn't agree, or the hospital or the physician wanted
They're
to
in
continue
private practice, or
in private practice, and so then they would be reported directly to us immediately. And what
right,
sort
not
of
to the public, not
to
to
the
board
public,
in the
but to the
setting, but to the designee, who would then initiate a complaint being opened, and they would be contacted as an impaired licensee, and there's a different process for
right.
them
And
to
then
go
that would, and then what's since I'm new here, what's the between the time of a complaint and the time of sort of resolution or action, I guess, and public disclosure, assuming it a bad actor, what is the time? How long does that take?
That takes time, and that's part of why a program could be so useful, because a program can act quickly. For the board to take action, for example, with an interim suspension order, that person has to either stipulate that they won't practice, and that would be posted on their profile that they are subject to a suspension order, or the board may have to compel them to go through an evaluation and then seek an interim suspension order with the Office of Administrative Hearings, where an ALJ would impose it.
And Ms. Webb, that could take 6 months, a year, longer?
You know, it takes time.
Time.
Yes, it's not impossible. And the board has to, for the interim suspension order to remain in place, the board has to be ready to go with its full case within 30 days. So there has to be an investigation to be able to go to hearing and prove by clear and convincing evidence before the interim suspension order dissolves that this person is not safe to practice and they need to be suspended, revoked, whatever action.
Okay. Ms. Remke, did you have a question on that?
Yeah, just on that issue, and I'm curious, and perhaps Dr. Bundy could respond as to other practices, and maybe this would be too much of a deterrent for people to participate, but there does seem to be, what if there was a finding by these professionals that we are somewhat delegating the oversight of these individuals to, if there was a finding that they were not safe to practice, that the participant agrees to be placed on inactive for, like, that triggers an automatic inactive, which then, until there's a final determination, I mean, that's kind of like the hammer. They've agreed they should go into this program. They've agreed to the conditions of the program, and they will receive somewhat of a benefit under the disciplinary umbrella. But more importantly, by going into it and then not complying or being determined to be unsafe, couldn't we say, if that's findings made and they don't agree to go inactive, we can place them on inactive?
Yeah.
Automatic suspension.
They can stipulate to that. If they don't stipulate to it, then the board has to prove its
Right.
case.
I'm saying as a condition of going into the program, they are stipulating to that.
Yeah.
Once a determination is made by a professional that we have delegated to oversee their care.
Yeah, what I'm hearing is, so what I'm hearing is you're suggesting we could include that in the proposal, right?
I'm just,
That it could be
first I'm
legislated,
suggesting
that
it
there's
as-
certain automatic
Yeah.
suspension. that goes
Just
into
as a
place, but-
possibility, but I'm also curious if that's done anywhere. And is that such a deterrent that nobody goes into it? And I wouldn't want to do it then. It just seems to me we don't want to go down the road of creating a program, great care, oversight, non-compliance, and we're just back to square one of having to go through the process of trying to get them on inactive. It seems like something should trigger a faster safety guard. Maybe, and I'm happy to hear, no, that's not a good idea from the professional's point of view, but.
Ms. Mitchell, were you finished up with your question? Sorry, I skipped around there.
No. I think that that's a valid point, and thank you for answering my questions and my naivete in this.
Thanks, Mr. Watkins, and then I'm going to look around for any other. Oh, I'm sorry. We have Dr. Ayala Rodriguez, who's been holding his hand up repeatedly, and I've passed over.
Mine is a little bit different, so I think that this one is connected to that comment. So please go ahead.
You see, this is the process that I'm talking about. The way Kerry explains everything and maps it out, we can elaborate on that. For example, in that case, right, where, you know, we say we are trying, this is what we currently have, a 3-year process, or we can't do an interim suspension order, or we can't really stop the physician from practicing if there's issues that arose, right? This program promises to remedy that, right? And will have the legal foundation. Now it becomes, then the question is always, this is what will alleviate people's concerns, is if you tell me, California, very litigious, right? They go all in with the attorneys, the whole 9 yards, and they can argue really well. So here's the deal. When we talk about the physician health program, having this authority, right, this legislative authority, I'm asking if those timelines estimated, what would that look like? And how can we, and I know life doesn't come with guarantees, but pretty much probability wise say this will happen 80% of the time. Do you see? It will happen better than it has happened in the current system. That's what we are talking about.
And Dr. Bundy may be able to describe some of that process.
Yeah, I mean, I think overall, it feels like the discussion is sort of really in the weeds, and I understand the need to kind of like understand how this is going to all be operationalized. But I can tell you it shouldn't be operationalized in legislation. You might include words in legislation like timely reporting of the PHP for concerns of impairment. You might use other words like immediate reporting of concerns of impairment, later to be determined between the board and the PHP what you mean by that. Because ultimately, in order for a PHP to be authorized in a state, it really has to be the selected program of the board. So that program is going to feel a high level of accountability to you all and what it is that you expect. I think the issue of when and how to report, critical. I meet with the board attorneys and investigators on a quarterly basis, and we talk in general terms about these issues to make sure that the porridge is just right. You don't want to be reporting people or sending people to the board or inactivating their license when they're a confidential participant. You want to take that lightly. You don't want to forfeit that confidentiality lightly, or the concern that was raised. I think that would be damaging to the utilization of the program, which is counterproductive. I do think that you ultimately have to feel as though you can trust your PHP to make the right call, to hold people out of practice when they're unsafe, and that you don't need to know about everybody who's unsafe so long as the PHP feels as though they have appropriate accountability and measures in place to make sure that that individual is not practicing, not putting patients in harm's way until that individual is rehabilitated and fit to return to practice. And that can all happen in Washington in 85 to 90% of the cases. That can happen without board oversight or knowledge whatsoever, because we are working very carefully to protect the public. You have to remember that a PHP's reputation, I mean, we can only do what we do in Washington with the trust of the medical board. So if in the 40 years that we were doing this, if we were hiding out bad doctors who were harming patients, we wouldn't exist. We wouldn't be around. And we want to be around because we do want to help and assist our peers and colleagues. So these are all really important issues. I think that they're all gonna have to be sorted out, and I definitely appreciate where you are all at in terms of starting to really think deeply about these issues. It tells me that you are well on the way to the process that needs to occur. I would say, as a point of clarification, just from a comment that was made earlier, I would think about how you use voluntary versus confidential. I think for people who are unknown to the board, I would use the term confidential. Technically, I believe that all participation in the PHP is voluntary. Even when somebody's ordered by the board to participate in the PHP, that's a choice. An individual could choose not to agree to be in the PHP and then face whatever disciplinary actions you all might take as a result of that. But ultimately their choice to be in the PHP is voluntary, and it's a voluntary program. We use the term mandated to differentiate participants who are ordered by the board to be in the program. And I think that those are conceptual distinctions, going back to some comment that was made earlier about, well, if somebody's being insisted to go to the program by their employer or their credentialing entity, are they really voluntary? I say yes, they are still considered voluntary in that program. They are not mandated, however, by a board or a board order, which is a different classification of participant in most physician health programs. So thank you for allowing me that last sort of editorial comment on use of language. And I hope that my foregoing comments also address some of the issues and concerns that were raised.
Thanks, Dr. Bundy. Dr. Ayala Rodriguez, please.
Thank you so much. So thank you so much for the discussion and everything. I do believe that as we find the author, it's going to be very important that the draft truly represents all the stakeholders and that we're representing everyone. I think that from the budget perspective, I have heard that a couple of times. I think that it's very important to address that even as we try to find the author for the legislation, because also we have to show like how soon are we willing to execute this as well? Because, for example, there's going to be a new bill. There's already a bill signed for a medical school in Kern County, and it calls 10 years of funding until the execution of the bill. So in this particular case, we want to do a PHP. It would be interesting to consider a period of funding time. Yes, donations, yes, other forms of funding, but is that something that we are considering doing next year or in 3 years? So I think that a funding period of time, like maybe it's something that an author would make them accept more the proposal, because everyone knows that the state and everything, like we have to really be fiscally responsible about this. Specifically because there was just a recent change in the licensing fee. So we don't want to trigger something that it's going to destroy the budget. So I think that we just have to really create awareness towards that. Then the second component of it, I think that it's very important to have the best practices. In my mind, when I see best practices, and I see a new project, project management and things like that, I also see at different phases. It's very important for us to have a vision of what we want to build. But sometimes that doesn't mean that the version number 1 has to meet all of the best standards, because some of the best standards for this particular project are going to require a lot of consumer trust that maybe we're not ready to delegate right now. But some of them are going to require money. Some of them are going to require different form of resources. So from my perspective, like I really want us to see this as a phase approach with a timeline that really tries to capture and evolve, because it's not going to be perfect from day one. All of us are providing a lot of very good feedback, but we have to understand where we are. There's other priorities that are currently being addressed, so we need time to address and improve on those priorities. But at the same time, right now, what do we do with consumer trust? And for example, for me, that is very important, because this project, for me, right now, as how it should start, is like 2 phases: self-referrals, third-party referrals. Self-referrals, someone that voluntarily refers themselves to the program, gets timely evaluated, gets fit, safe to practice medicine. Maybe for that person, like really we can do exemption of the uniform standards as long as there's no pending allegations, no sexual conduct allegations, no new developments. But if the person is not non-compliant, if there's new developments, definitely something needs to happen to trigger a different pathway, which was already discussed. But as a phase 1, maybe all third-party referrals, like, yes, they go to the PHP for the timely evaluation, but maybe the uniform standards have to stay for as a group, at least for phase 1, because this is something that we're going to be building. I think that it has to exist, but I think that it has to be strategically timed, and it has to evolve strategically to get all the support that we need, and specifically because we want it to grow and improve.
Thanks, Dr. Ayala Rodriguez. I'm going to go to Dr. Boat. I think you had your hand up, and then maybe after that, we'll take a little bit of a straw poll to see where we're at in terms of advancing towards a motion.
Thank you, Madam President. A couple of issues I wanted to ask Dr. Bundy. Number 1, in terms of what you find between the local physician wellness, health and wellness programs in large institutions, then the medical and the discussions with medical staff, speaking to Dr. Mahmoud's point that people, although may have an ethical responsibility to report an impaired colleague, often do not. I'd like to know your thoughts on the interplay between the local PHWP within the state of Washington, the medical staff, 805 reporting, and and if I remember your slide, you actually showed at one point the increase in the number of referrals. So just to cut some context to it, in the general population, 10 to 12% of individuals have a substance use disorder, and that's not much different for the physician population. However, I think you showed data that, and we have that data too, to some extent, it's much lower as reported based upon the number of cases that come our way, maybe 4%, 5%, 6%. So recapping, just that interplay between the local PHWP, the med staff, 805 reporting, and the trust that you've been able to build in Washington between these entities. Are they in conflict or are they in collaboration?
Can you explain what 805 reporting is?
Oh, I shouldn't use terms. I'll look to my colleague.
Sure, I suspected that would come up. For California, an 805 report is a required report by a peer review body if certain findings are made. So if the person is denied privileges or their privileges are terminated for a medical disciplinary cause or reason, then an 805 report is required to be filed with the board. And that's just a couple of examples.
So maybe this is the place to sort of talk a little bit about mandated versus non-mandated reporting states. About 2/3 of states have mandatory reporting at my last count. I'm not sure when the FSMB last updated this data, but my recollection is about 2/3 of states have mandated reporting laws related to impairment. Meaning, in Washington, any Department of Health license holder in any healing arts profession is a mandated reporter of concerns of impairment. But so too are healthcare organizations, hospital systems, professional liability carriers, and so on. Peer review committees are also mandated reporters, but they are allowed to undertake their process so long as they are engaged in timely investigation of their matter. They are not required to report unless they have determined that they otherwise meet a reporting obligation. So in all of those cases, what happens in Washington is that our statutes, our enabling statutes for the PHP, allow you, any one of those mandated reporters, to make a report to the WP, to our program, in lieu of a report to the licensing board. That's a critical piece of the puzzle here. Not that I'm saying it's critical that California have mandated reporting to the medical board. You could have a mandated reporting law that says that all concerns of impairment are mandated to be reported to the physician health and wellness program as the initial step, knowing that your physician health and wellness program will also have a statutory obligation to report if they can't keep patients safe or an individual fails to follow program requirements. But my point in all of this is that these various bodies, we have hospital wellness programs or physician or wellness committees, I should say, that are, like in a lot of hospitals, they work in tandem to or outside of the medical executive committee to help deal with, in a non-disciplinary way, according to Joint Commission standards, for example, to have a non-disciplinary pathway for dealing with illness and impairment amongst the medical staff or amongst employees in a healthcare system. So our job is to make sure that all of those entities have awareness of who we are, what we do, and that they can discharge this legal/ethical requirement for reporting or addressing concerns of impairment through the physician health program. And we believe that increases participation. To your point, lifetime risk is 20 to 30% of individuals will have a substance use disorder. 1 year, 12-month risk, current risk is 10 to 12%. Leap and Fromson estimate that at any one point in time, 1 to 2% of practicing physicians may be actually impaired as a result of a health condition. So that's our target in terms of penetration. Currently, we're about 1 to 1.5% for MDs and PAs in Washington State. So we feel like we're kind of at the right spot, that we're getting the right population, that medical staff and employers are making appropriate referrals pursuant to their obligation. We also use that as a mechanism for education to remind people, because a lot of people actually don't know that they have a mandated reporting requirement, and they don't know when that requirement is actually triggered. Concern for impairment is the trigger in Washington, unless you're a treating provider of that individual, that physician, in which case clear and present danger is the trigger for mandating a reporting requirement. So a lot to unpack inside of that, and I'm not sure I'm totally answering your question. But definitely there is an ethical and legal obligation in Washington State to report concerns of impairment, which can be discharged by contacting us. And that is helpful because I would tell you that historically only about 10% of people are true self-referrals to the program. So those are people who say, you know, I've heard the good news about the physician health program. I know that I have an issue that you guys can help me solve, and I'm going to refer myself, and there's no outside leverage involved in that referral. But 40% of our referrals are from employers and health systems. We also have another 27% of referrals that are from graduate medical education and undergraduate medical education. So a big chunk, all of those usually coming with some sort of external motivation for participation in the program.
Oh, thank you, Dr. Bundy. One last point, you mentioned the education, and I'm thinking of, we have our many stakeholders in this endeavor, and in terms of ACGME, the Accreditation Council for Graduate Medical Education, or the Liaison Committee on MedEd for Undergraduate Medical Education, have you engaged with that group? Because at the get-go, these issues, and I almost put it under the rubric of professionalism, and that has to be modeled. And as far as have you worked with either of those agencies, and what has been the commentary from ACGME and LCME?
Great question. Glad you asked. Actually, I was just in Chicago last week at the ACGME Wellness Symposium as an invitee to participate in that. And we've been very involved with graduate medical education on the national level. Less so with the LCME, but AAMC definitely in collaboration with them, as well as the AMA. The issues of, you know, undergraduate and graduate medical education barriers are more significant in terms of cost. You know, while you're talking about funding the program and perhaps subsidizing that with a surcharge on licenses or other sources of program funding and support, access to services, especially the kind of specialized services that safety sensitive workers need in order to verify safe practice, to evaluate fitness. That doesn't happen at, you know, your local psychiatry department. I've been in clinical faculty in my department for 30 years. My department doesn't have the resources or expertise. A lot of smart psychiatrists in our department that can do lots of things, but this is work that they frankly can't and don't want to do because it's resource intensive, so on and so forth. So finding those resources for students and residents and ways to pay for it will be a challenge for any, and continues to be a challenge for any physician health program. We wrote a paper on that with Amy Vinson at Harvard a couple of years ago, looking at barriers to access and utilization of these programs for students and trainees. So we're definitely, you know, having lots of discussions about how we can adjust our programs, adjust our expectations, understanding the unique needs of those two populations. But we also feel it's incredibly valuable to get those folks in early at a time in their career where we can prevent a lot of negative professional consequences to care. So, you know, important to be in there educating. So we're in their curricula as residents, we're in their orientations, we're in, you know, to raise awareness about what it is that we do, to raise awareness about health and well-being, to raise awareness about their professional obligation to attend to their health and well-being. So there's that, prevention aspect of getting in and providing the education, but there's also the being available when, the club that nobody really wants to belong to is one that you suddenly qualify for. And so, in that way, we're trying to better serve those populations.
Thank you, Dr. Bundy, and thank you, Dr. Balot, for those questions. I think I'd like to just do a check-in. There's a recommended staff motion to direct staff to work with the legislature to find an author for the bill to carry this particular proposal, and then a second part of that, which would be to authorize Vice President Helzer and me to work with staff, the legislature, and stakeholders to move forward with the proposal. Is there anybody who disagrees that we should continue to advance this? I'll ask the question that way. You disagree we should continue to advance the proposal? Okay. Anyone else? Okay. Yes?
Sorry. I'm sorry. I appreciate. Well, it just, I thought, I guess my question is, I know that part of the reason for Vice President Helzer and yourself being the key agents is it's a hard enough thing to process legislation and to get it forwarded and moved through. But I did wonder, would Ms. Torres and Dr. Yip have any role in that process, or is their role completed now?
No, so this is my point of view. We actually haven't discussed this more broadly, but I think they'd be important collaborators in the process. I think that the idea is, with providing this authorization is much like sunset, so that the board staff have, a designated couple of people from the board to go to help with questions that come up. I also want to reinforce we have a January meeting, I'm forgetting, an April meeting, now I'm going to get off on our schedule.
5 meetings next year, potentially.
Potentially 5 meetings next year. We would be back to all of you at those meetings also, right? To invite input, especially to the extent this finds an author and begins to work its way through the process. There's lots of check-ins with this whole group, but I would expect that we'd also check in and use the wisdom and potentially have additional task force meetings as we work the way through the process. That process is not decided as of yet, because I think we need to know whether we're moving forward. But I think I hear you saying that perhaps you'd like to see them continue to be involved and that the task force continue to be active, and I support that.
That's the yes to that.
I support that. Dr. Yip?
I'm speaking now as a board member, partner as a task force. So this very nice learning experience for me as a board member coming back. I'm really, really excited about that. Even before I was put on a task force, I start research on this process. And just to make it short, I know someone had to play the catch. I have talked to like 4 universities. The people actively involved in the PHWP in their own campus. And one campus had the office vitality that they want me to all the medical student, resident, and fellow came on board. They have 3,500 faculty. They have vitality. They also have formal physical well-being program that monitor physical need help, treatment, etc. 35% of the faculty, resident, student, one time or the other approach help. So there's a need there. And second, university, they actually get a $2 million funding from UNICEF to start a mental health program. And in the random email monthly to the student, 9% of them show suicidal ideation. So this is a problem we're facing, not just the healthcare. Healthcare profession is a safety-sensitive profession. We need to take a lead in that. 2 UC campus, one of them actually active. I talked to like 5 faculty, different departments about the concept. Actually interesting that TJ bring it up. I was quote unquote warned about the uniform standard. And the faculty mentioned you would face headwind about that. And TJ mentioned there is loophole and flexibility. That's what this program is about. As for funding, interesting I learned is that you don't have a story to tell, you cannot get funding. So you have to a story to tell to get funding, okay? And we volunteer with the president, vice president. We're happy to sit with the potential legislator to sell a story that we hopefully all agree on. This is only the first step. There are many, many, many like meetings like that. I'm very impressed by TJ, by Ms. Remke, and Mitchell. First meeting, very, very positive comment. And that's actually one of the items we discussed among the task force is that how do we present it? And we agreed to present as comprehensive as possible because we need you to understand. And I urge you to go home and read it again, look at Dr. Bundy, Dr. Early's presentation without distraction, read the Uniform Standard, and read the Senate Bill 1441. They have a lot of background, and that tells you why we need to do this, okay? The other thing I want to share is that the concept of protect the public is always there. The idea is that the program have the ability, hopefully, to catch one is the volunteer participant who we'll never know anyway, but they may not like the system or the people in the school. They don't want so-and-so Dr. see you walking in the office. I can tell you one high school in Los Angeles had a suicide problem because students are afraid to walk into the office to be counseled. So a program like this, at least it helps the confidential part that encourage people who need license to help to walk in that program. And the second is that the mandate one, we are not deviating from uniform standard. I think we have a misconception out there that we're dropping uniform. We're not, okay? We actually stick to it. Enforcement stick to it every day. But there is a gray zone that we want to, with the feedback, how do we not capture, how we capture those data, those licensed who need help, who we can do something to prevent them from getting impaired and cause patient harm. That's the key thing. That's the beauty of this program, okay? Now, the other thing is that I think that it's very important that I think they define the term stakeholder. I think that misunderstanding stakeholder means the public. Stakeholders also mean the doctors, the society. So as far as funding, I thought about, yes, the legislator may come with funding, and I talked to some of the HMO, the executive. They were asked to trim 3% to the Medicare fund, which people kind of say, well, we don't know what happened to that. But I think if a good story to tell, I think we can post that. Even NIH, maybe we submit a proposal to ask for, this is public health issue. And again, I'm meeting one of the UC office on Sunday. Hopefully I can sell a story that the philanthropy can chip in the seeding for this program. But again, we don't have step one. We dropped the ball today. We go back 15 years ago and we move on. We're going to hear all these things. What happened to our licensee? What happened to our unhealthy doctor? Nobody's going to take care of the patient. We don't have a doctor, et cetera, et cetera. So I think I'm so glad TJ didn't say today, say drop it. But TJ a lot of suggestions, which I really think is very valuable. So I do encourage the board member, study, and support the program. Carrie and Reggie and Aaron, believe me, Ms. Torres, they really work a lot behind the scene to bring this. And we'll continue to support Ms. Lawson and Doug Hauser. If we need to go to a meeting, lobby the legislator, we'll be there. Thank you.
Mr. Watkins.
And here's the irony of all of this. I agree with all of that. But however, you see, I am in coaching and relationship game. And so there's this fine moment that comes in a relationship where you take a step back, pause, and you come back to it. And you come back to it with these types of things. I know what the other party's concerns were, what their objections were. I'm asking them to raise those objections, but I'm already coming with solutions for those objections. For example, what have we learned here today? What I've learned here today is that when you put it in those legal language and all of the issues that we have seen, it doesn't resonate with the public. You can say to the public and to patient advocates all day long that this program protects the public. They won't see it. What I'm suggesting, why I suggested let's have a stakeholder face-to-face meeting and have people present solutions, is because I want to preserve the relationship, an opportunity for them to speak. But this is what we will do differently. We will say, hey, this is what the current system is doing, and this is what it will do better at level 1, level 2, level 3, level 2. It needs to be more simplified. And I know that's a little bit more work, but to clarify it. And we say, this is what the program promises to do, and we'll do our very, very best to make sure that this program pushes that through to the legislature and to all the process. But we want to preserve the relationship. And sometimes we act too quickly and we lose the relationship, and then we lose so much traction. And I see we are all in agreement, but I just want to not lose the relationship with the public that Christina has worked hard to build through all the, and Regia has worked hard to build, the staff has been hard to build. One moment. We do another meeting, my suggestion, at the next board meeting, since we're meeting so many times, and we just say, hey, cut a board meeting by 2 hours, and we meet with but these are the criteria. It's a dialogue. You actually have to bring solutions. The folks out of San Diego bring solutions. The folks out of Bakersfield bring solutions. And then we make a decision. We have a decision now to move forward. But what if that decision gives you some critical points that alleviate some of their stresses? Then that thing moves so much more smoother. And that's the only thing I will ask today.
Thanks, Mr. Watkins. Dr. Yep?
Madam President.
So actually, when I make the call to the faculty who involved both program, actually I send the video link of the two presentations to them. One of the nice thing about one of the program is that in addition, confidentiality, accountability, is transparency. As a matter of fact, if I remember the Seattle program, Washington program, actually they have a public member on the board, and they're independent. So I think it's a good thing that we can follow. Thank you.
I guess I just want to indicate my alignment, Mr. Watkins, with you on making sure that the process is inclusive and that we have additional opportunities for stakeholder engagement in a variety of different ways. And I also want to share that I think there are going to be many, many opportunities for that stakeholder engagement, right? If we move forward today, I don't want us to lose the opportunity to have conversations with authors, which I really do think needs to happen as the session, as they come back or prior to them coming back into session. That doesn't mean, again, that the bill is necessarily moving forward precisely as drafted or that we won't have those opportunities. But I would hate for us to lose the opportunity to continue to progress the conversation today. Dr. Mahmood?
Yeah. Well, this is a really wonderful opportunity. There is no doubt this provide more protection to the public because we were able to get people identified who are at risk to harm the public. And we are also doing a favor to providers because they also are our responsibility, but keeping in mind that public is safe. At the same time, there has been so much discussion, and I think this discussion can continue going on. I believe that everybody over here agree that this is a phenomenal thing and we should move forward. But doing the fine tuning and getting all the suggestions today and making the language more acceptable to everybody and keeping public also in a situation where we care about them. We are here actually for the protection of people. And they are the major stakeholder. We are not the stakeholders. We are doing this thing. I think giving a little more time until next meeting, I would agree with that. And I think that will create a better trust, that will give us more understanding, and people who are for the first time hearing, they will also understand and study this more. And new assembly is coming. Those people are not going to be even ready right now. Half of them will be learning how to run the process. I think if it's 2 months or 3 months from now, I think it's not going to be much wastage of time, but the asset we will and the possibility of this really success will be much bigger if we come back and talk about this thing more and make this happen. But I definitely hope that this thing can move forward very soon.
Dr. Helzer?
Thank you. I'd like to thank the task force members and the board staff for their work on this proposal, the board members for the robust discussion, and members of the public for sharing their stories and perspectives. During the course of my career, a number of my colleagues have died as a result of substance abuse related to their professional practice. And I've often thought about them and wondered what we could do to prevent that from happening. And I'd like to think that a well-functioning PHP might have prevented some of those tragic outcomes. I also believe the sentiment, or agree with the sentiment that's been shared previously, that a well-functioning PHP, by aiding in early identification and treatment of impaired physicians, will improve patient care, public safety, and further the mission of the board. So I would urge you all to agree to support this proposal. Thank you.
Would someone like to make a motion? There's a staff recommended motion.
I'll make the motion to adopt the staff's recommended motion. Is that it? I can't read it.
I think that works. Thank you.
I second.
Thank you. In a second. All right. Is there any further discussion?
Yes, just the last.
Mr. Watkins?
This is my last comment. You know, the deal with this is I totally empathize with Dr. Elza. But right now, we have all the stakeholders except the public, which we are mandated to protect, on board. That's a big consideration. And that's a big thing. If we lose that now, they don't, it's not that they don't understand. I don't want to be ridiculous when I say that. It's that they need more time, just a moment more. Sometimes in life, it's just a moment to have a conversation, what we call a clearing conversation with people, to bring them on the page, because they may have to realize there might be a greater benefit than the pain and the fear that is blocking them from seeing it in that moment. That's the only way, that's the only reason why I feel like we can't, it's at a high risk of losing a relationship that we have been meaning to build. And the irony of this is, we have skill, we've got Aaron and got Ms. Mitchell on this panel that can negotiate, that can start talking, because this is pretty much in the bag. What we just want to do is take a moment, one moment, to make sure we're bringing somebody that's still in fear on board. And that's my only hesitation, that I urge people to reconsider, even at this late juncture, because it's so important to have that relationship. This is the medical board. We fought so hard to get to this moment. I've been on this board, Mr. Chair, all of us, for this moment. This is that critical moment where you can see, okay, they pause for a moment and they listen to us. When we do the same thing down in 2 months, they were heard, they were considered, they were given priority. That's a big thing. It means nothing now, because we want what we want, and we may see things that they don't, but we do have a responsibility to communicate that clearly. It's not communicated clearly about what the potential benefits are. It's in legal language right now. And I wouldn't ask this if this wasn't very important. I can see the room. You can read the room. It is, we know what we want to do, but we just need to bring a team member up to par this moment. A team member that will fall back into their pain, back into their defensiveness, if we don't listen to them, because they did it once. After the first stakeholder meeting, they didn't even bother to come back into the second stakeholder meeting. A few did. There were many on the first meeting, not so many on the second meeting. And I was surprised. That's how you lose a relationship. It's just important for me. I know I'm babbling on, but that's how passionate I am about restoring relationships.
Thanks, Mr.
Thank you.
Watkins. Any further comments before I ask Dr. Sai?
My view is I think TJ's completely correct. I think the big picture of how I look at it is, are we in favor of this program? I think all of us on the board is in favor of it. And I analogize it to, we're building a house and the stakeholders should be involved on where the bathroom goes, where the kitchen goes, and we all have to live in this house together. Now, obviously, if we don't think the house should be built, then you should vote no on this motion because it's so early in the process that I think the stakeholders need to come along. I completely agree with TJ. Bring your solutions. Bring where you want, which room you want in this house. And so voting for this now allows us to move forward together and trying to figure it out rather than, well, we're going to wait a month because I think this is very, very important. And to say, let's wait and get more input, unless you feel like we shouldn't build this house, that's how I feel like you should vote no on this motion. That's why I'm in support of this motion.
All right. I gave you a lot of time to speak, Mr. Watkins. Let's call, unless there's any new comment that someone would like to make, let's have the roll call vote, please. Ms. Strother?
Dr. Ayala Rodriguez,
Yes.
Dr. Bullock, Ms. Chung. Yes. Dr. Helzer,
Yes.
Ms. Mitchell,
Yes.
Dr. Mahmood,
Yes.
Ms. Rimke,
Yes.
Dr. Thorpe,
Yes.
Ms. Torres,
Yes.
Dr. Sai,
Yes.
Mr. Watkins, Dr. Yip,
Yes.
Ms. Lawson.
Yes. All right, that motion carries. Thank you all for an excellent discussion, and we'll look forward to checking in with you a lot as this continues
Madam President.
to progress.
I mean, Mr. Bone mentioned something early that I don't think we really accomplished. We did agree with everyone. I mean, been done. And I am empathetic with all of the difficult and tragic situations. But Mr. Bone earlier had said he was concerned that we have a core of must-haves in this legislation. And I don't know that we accomplished that. And I mean, is the must-haves the whole thing, or are we, I mean, to me, the must-haves are, there has to be a confidential reporting mechanism. There has to be a mandatory mechanism. There has to be a funding source at some point. I mean, to me, those are the must-haves, and maybe there's more, but those are the ones, for at least from my perspective. But I don't know if everyone agrees on that. We didn't really have a motion on that, and I'm not trying to force the issue, but I'm also trying to make sure that we have a successful process going forward. And I agree that we need to include the public and patient safety advocates in this process and bring them along with us, because I think it's critical that there be.
Thanks, Dr. Yeah, thanks, Dr. Thorpe. So a couple thoughts. I think that we were all listening. I was certainly listening. I think our staff were listening to the comments we were hearing and taking notes as to where we were hearing common themes. Funding, I'll use as an example. That was a common theme. Also, the comments that Ms. Remke raised that were raised then successively by others. So I think we have a sense of where there is consensus. We will be back to you in relatively short order, likely in January, right, to have more conversations about this. And at that point, we'll also know what requests we may have received from an author, potentially, about what those are. So I think that we have enough information today, even though we didn't call the question in precisely the way that Mr. Bone suggested in his remarks. I do think we have enough information, at least to start the conversations and to understand. I think we have a good understanding where the board is at this particular point in time. And it's on all of those issues that you articulated as well. Mr. Bone, do you think you need any more information from us?
Oh, good question, Madam President.
Recognizing you could always use more information from us.
Aaron, I was going to help you. Actually, one of the to-do lists is to reach out to the Federation states to see what others doing, with the reminder we California are more consumer sensitive. What I'm saying, their practice may not be the best for us. We have a different environment. We have more sensitive member and more engaged public, but we can reach out what are the musts in the program, in the contract, etc., and then we do our way with all the public input. Thank you.
All right, I think we will just move along at this point. I think we'll conclude this item. As everyone knows, actually the new members don't know this. We're now moving on to agenda item 13, my favorite item, future agenda items. Do any members have suggestions for future agenda items? Yeah. Mr. Watkins.
My last ditch effort, maybe perhaps at the next board meeting, we can have an in-phase stakeholder meeting. I think it's important that we do that and just to bring people online.
Great.
Yeah, I want to bring back.
I think your mic is not on.
If it's on, I'm far away. I want to bring back one important issue now again, update on vaccination and future holding us in next 4 years. California might be facing off with feds, and vaccination is going to be a very important issue. What are the mandatory, where the progress has been done after pandemic, and get some expert on here, the latest update on vaccination.
Thank you. Dr. Thorpe?
I would like to see an agenda item on the update of the multi-state injunction against pharmaceutical distributors and pharmaceutical companies.
Okay. Great. Dr. Yip?
I know Kerry is very competent. Just one suggestion I make, and not immediately, but in the future, I think there's a disparity between the healthcare profession, medical professional, and the public now. I think the trust is eroding, the integrity is eroding, and the new generation different. They like to work, salary job, etc. So maybe down the line we can, with the help of the staff, create a slide set, kind of lay out how our medical board mission, our complaint process, what may happen if you don't perform what you need to be a good doctor. I used to give a grand round with Renee way back when I first came to the board, to give talk on the 7 sins, to tell the licensee how to protect your most valuable asset, which is your license. So we have a lot of entrusted board member, and I think there's only 9 or 10 medical schools in California. If we have a agreed upon slide set information, maybe we help to the DAG, certain like 10, 20 sample cases, and tell the next generation doctor, how do you gain trust, obtain consent, communication, best practice, etc. So that's my suggestion for the future. Thank you.
Thanks, Dr. Yip. Other future agenda items, Dr. Ayala Rodriguez?
Thank you. I would like to eventually close the loop on AI, because I believe that every day there's more and more adaptation of AI. There's like more community health centers using AI. Other industries is very affordable. It's like about like $1 or less, like the AI integration per encounter. So I don't want us to think that it's something very complex that no one is adopting or no one is using, because everyone is using it more and more and more. And I think that at the very least, like, we should have some best practices or awareness points, something towards AI utilization. And having said that, if we were to do a task force or something, maybe just a revision of the listed task force on the website, to see like what's active, what's not active, clean up with that. Thank you.
Yeah, I appreciate that. Thank you. That's a good suggestion. Other future agenda items? Okay, let's open it up to the public in the room. Any comments, any future agenda items you'd like to share? Feel free to come up. I gotta have you come up and make public comment. Thanks.
Marcus Friedman from the Consumer Protection Policy Center. I agree with Mr. Watkins in having a discussion with stakeholder members as to the proposed physician health and wellness program. While there's other stakeholder meetings that were given, some of us cannot make it, and then those who can are only given an opportunity to speak for 2 to 3 minutes, and it's not so much of a conversation at that point. There are multiple recommendations that we do have, we put in writing. I think it is beneficial to have it face to face to kind of discuss it and flesh it out a little bit more. Thank you.
Thank you. Other public comments on future agenda items? Please just come on up. Please.
I just push it? Oh, okay.
Ya me conocen, soy la mamá de Snyder.
She said, you guys already know me, my name. I'm the mom of Snyder.
Vos lo conocía por medio de mi licencia de cosmetóloga.
She said that she
Cosmetología.
she said that she wants to speak to you guys about the topic again.
¿Verdad? Pues son muchísimas las reglas hasta para cuidar a una persona con su cabello.
She said that there should be a lot of regulations when it comes to taking care of somebody.
Fui a sacar mi licencia.
She want to take out her license as well.
Lo único que le puedo decir es esto.
She said that the only thing she's able to tell you guys is this.
Un doctor,
A doctor,
neurocirujano,
a neurosurgeon,
cualquier persona.
or any other person.
Solamente estamos hablando del tema de una rehabilitación o darle una oportunidad a esa persona.
That, what is it address?
Darle una oportunidad a esa persona.
Al doctor. To give the doctor an opportunity.
No estamos pensando que del momento que un doctor
We're not thinking about the moment
toma la decisión de
to
usar
make a decision of using alcohol or drugs,
ya mentalmente hay un problema.
that there is a problem.
También no nos estamos acordando
We're not remembering
que depende de la droga que utilice,
that it depends on the drugs
tanto el alcohol,
or the alcohol
cualquier tipo de droga,
or any type of drugs,
te daña neurológicamente.
that it will mess you up neurologically.
Y no soy doctora, pero
I'm not a doctor myself. ¿Puedes decir eso otra vez?
tus manos quizá ya no sean las mismas.
Your hands will not be the same after you touch drugs or any alcohol. Would you guys like
Que a uno de sus hijos a ustedes,
if one of your sons,
un doctor neuro, cualquier cirugía que necesitemos,
a doctor or any neurosurgeon,
se animarían a poner su cuerpo que les hiciera una operación?
would you like if your kids or one of your family members were have to get a surgery or something major done to them if the doctor is under under drugs?
Forgive me. I want to be sensitive to your experience, but you're talking about the prior agenda item. This is, do you have a request for a future agenda item?
El hablar del futuro
To speak about the future is to leave a door open
para que cualquier doctor pueda cometer cualquier negligencia, algo positiva con alcohol.
is for the doctors to be able to be under the influence and you guys will not do anything about it.
Estoy protegido.
And they are protected.
Usted habló de la licencia del DMV.
You spoke about the license of
DUI.
of the DUI.
Tenemos consecuencias.
There are consequences.
Si a mí me agarran tomado, me dan una consecuencia.
If she were to be caught in drinking and driving, there will be consequences for her.
Segunda vez, me cancelan 5 años mi licencia.
Second time, if she were to get caught, she will be suspended license or face jail time.
Pero si yo le atropello a su hijo
But if I were to run over your child
por estar tomada,
to be under the influence, while being under the influence,
la vida de su hijo,
the life of your
voy
child,
a pagar yo dentro de una cárcel.
that she will have to pay that by being behind bars.
¿Quién nos va a responder
Who's going to respond
si una persona
if a person
ya su mente por tanto alcohol y droga no
that their mental
Please conclude. It's off topic, so I've let you discuss it.
Can I mention something? I'm going to say in Spanish, then I'll say it in English. El tema sobre que están hablando del programa de physicians que están tomando drogas o que tengan algún problema, no se termina aquí. Va a continuar en enero y luego también en febrero. Entonces la discusión ahorita es del futuro.
¿Sabe qué quisiera yo? Que nos tomaran en cuenta en público, porque el señor Joaquín tiene mucha razón.
Do you still want me to translate for her?
We need to conclude.
Oh, okay. Okay.
Tiene mucha razón.
She said that the man, TJ, that he has a lot of reasonings.
Nosotros
Ourselves.
quedaremos más en ustedes.
So my apologies, we have to move on.
Ya terminaron. Dice que ya.
So we'd be happy to, I'd like our staff to connect with you afterwards to make sure that you know about our complaint process and know how to engage. But from the board meeting perspective, we need to move on.
Sí.
Thank you.
That's fine.
Mucho lo queremos hacer.
That's fine.
Thank you. Thank you.
Thank you.
Okay, any other future agenda items in the room? I'll come back to you before we close out the item. Sean, are there any more on WebEx?
Yes, if you'd like to make a public comment on WebEx, please use the hand raising feature. Type something in the Q&A window. If you're in a call and only line, you can press *3 to toggle raising your hand. First up here, we have Monty Goddard. Monty, you should be receiving that prompt.
When I made this comment, when I wrote this comment, it was good morning. I got to tell you, I really respect the stamina and the dedication of all the members of the board. Let me start over. Good afternoon, Chair Lawson, board members, Executive Director Varghese, and staff. My name is Monty Goddard. I'm a licensed California civil engineer. I advocate for my wife, who has been an intractable pain patient for 2.5 decades. I'm a member of the Speakers Bureau of the National Campaign to Protect People in Pain. I'm requesting you agendize 2 critical issues impacting patient care in California. My first issue is the one Dr. Thorpe raised, and that is the ongoing harm to patients resulting from the injunctive relief provisions of the state AG's nationwide settlement with the 3 major distributors of controlled substances. The injunctive relief requires the settling distributors to develop and hold secret controlled substance order thresholds for each of their customer pharmacies or pharmacy chains. If a pharmacy submits an order or summation of orders exceeding the distributor's secret threshold for the pharmacy, the injunction requires the distributor to cease filling all orders for controlled substances to the pharmacy and to report the offending order as a suspicious order to the pharmacy's state board, AG, and the DEA. This truly iniquitous process causes pharmacies to err on the side of caution, resulting in inventory shortages and patient harm. Yesterday, Dr. Thorpe mentioned his attending a committee meeting of the Board of Pharmacy last month. I did also. This issue was on the agenda. At that meeting, board members expressed interest in teaming with the medical board and other impacted boards to jointly brief AG Bonta on this issue. The medical board needs to prioritize this issue. I look forward to seeing it on the agenda of your next meeting. My second agenda item request is for an assessment and discussion about what further actions must be taken to effectively promulgate your now over 1-year-old opioid prescribing guidelines. I contend the board's objective to encourage physicians to return to the treatment of chronic pain patients has not been achieved. For the benefit of any not familiar with the guidelines, I conclude my public comment with these 2 extracts from them. Quote, "It is recognized that the board's death certificate project and the CDC 2016 guidelines, a chilling effect was felt and physicians became less willing to treat patients with chronic pain." And quote, "As the board discussed the need to update the 2014 prescribing guidelines, it was emphasized that a change in tone was necessary to provide support and guidance to physicians to prescribe in a way that is effective for their patients and to also have enough flexibility to deal with pain patients that don't fall into the normal guidelines." Thank you very much.
Thank you for your public comment. Next up here, we have Marion Hollingsworth.
Hello.
Good afternoon, Marion. Please go ahead.
Okay, great. Thank you. This is Marion Hollingsworth, patient safety advocate. I endorse the plan to have in-person meetings as Mr. Watkins suggested. I think that's a great idea. But my second thought is, who's going to pay for this? A lot of people can't afford flights to Sacramento, hotel rooms. A trip like that could easily cost $1,000. And a lot of people are not in that position. And if you're going to have in-person meetings, it would be helpful to at least have multiple meetings in various cities to make it easier for people to be able to take part in them, unless the board thinks that they could fund X amount of people coming. So just to have, when you're thinking about in-person meetings, it's convenient for most of you, you're paid for, but it can be a real financial sacrifice for a lot of people and their families. Thank you.
Thank you for your public comment. Next up here, we have Black Patients Matter. Should be receiving that prompt.
Yes, hello, thank you. Black Patients Matter here. So future agenda items, we would really like to see a topic regarding mediation. I know that previously the board had made mention of being open to the idea, and perhaps this mediation idea could be integrated in some way with the physician's health and wellness program. It seems that another agenda item that would be of relevance is also minority health. And under minority health, something that would be of benefit is integrating spirituality into this health and wellness program, because what your statistics would show is that the majority of physicians who are penalized are minorities. And in fact, most minority physicians are spiritual believers. And so we know from data of those that have been incarcerated in the general public, those who have some type of spiritual belief have a decreased recidivism rate. So it would be of interest to discuss spirituality in terms of physician health and wellness, as well as mediation in regards to patient satisfaction, patient care, and recidivism, because an opportunity for a patient to sit down and hear from the doctor, and for the doctor to have an opportunity to empathize and to discuss
30 seconds
what would happen would be of benefit to all parties. Thank you.
Thank you very much for your public comment. Last in queue here, I have Tracy Dominguez. Tracy, you should be receiving that prompt. If you'd like to make a public comment and you haven't already for agenda item 13, please use the Q&A feature or raise your hand. Thank you, Tracy. Go ahead.
Okay, hi. I just got a couple little comments. I think that we need an interpreter for the families that are there. I think that they deserve that. I think that they should be able to express their feelings where they can communicate. And I also think that we should go talk about this further. Of course, you know how I feel about the topic anyways. And also, we're still waiting on the maternal mortality report. So those are my two comments. Thank you very much.
Thank you, Tracy. At this time, there are no additional requests in queue.
Thanks. No further public comments, John? Great. Thank you. All right, I'll bring it back. Dr. Ayala Rodriguez had one, and then we'll.
Sorry, it's on behalf of the public. Is there any opportunity in the future, like to talk about like the speaking time when we're using an interpreter, like maybe like remove the speaking time like for interpretation use or things like that?
Yeah, we did. I mean, for what it's worth, we did have the request prior to the meeting to allow for additional time, and we did try to allow for that additional time. And I think we were pretty generous with it today. But if there's any concerns about it, let me know.
And the time they get double the time. Right. The only reason I cut it off this last time is because it was off topic.
And we also are working with DCA on, how to make sure we have translation services available going forward as well. So that's something that's on our radar. Any other comments, questions? All right. Seeing none, the next item on our agenda is adjournment. Thank you all for your participation in this November board meeting. Our next board meeting is February 13th and 14th. That's the quarterly board meeting. We do have a hold on all of your calendars, I believe, for January 16th, which is a virtual meeting, I believe. No, it's in person.
It's an interim meeting, but it will have to be in person.
Okay. In-person meeting. There should be an interim meeting on everybody's calendar, correct? Yes.
Yeah.
Nobody has a calendar hold for January 16th?
It was, well, at the board's August board meeting,
Yes.
you all approved the calendar for 2025, and that January meeting was on
Okay.
that agenda.
Let's
That was
make
approved.
sure, though, that we circulate a hold to everybody so that
Yeah.
that's on everybody's calendars officially.
And then more to come, I think, if it will actually occur.
Yes. So
yeah.
it may, yeah. So let's make sure that we have the board circulate that to all the board members. And there being no further business, the meeting's adjourned. Thank you.
We'll send that around again.